Don't worry, immediately.
Published. Lord, application in connection with matrimonial appeal.
All applications give.
Maybe permitted to mention a urgent inclusion on the list, Lordship. It's a matter. Maybe permitted to mention an inclusion in the list, Lordship.
Appeal or what?
Appeal of matrimonial appeal.
Wait for
Lordship.
this week. Let
Lordship.
us see. We have disposed of one. We could hear.
Lordship.
Just one or two matters. Let us dispose of. We'll include it.
Lordship, kindly, Lordship, on the last occasion, your Lordship has ordered for.
Hey, let us come. Next week you come.
May I be permitted to mention one matter for non-prosecution?
Oh.
This is the instruction matter.
The counsel for the appellant submits on instruction received by him in writing from his client that his client does not intend to proceed with the instant appeal as well as the application while there. Let the written instruction received by the advocate and record of the appellant be taken on record. In view of the above, the appeal and the applications are dismissed for non-prosecution.
Item 2. I am for the respondent. Respondent. This is
What correction, sir?
correction, my lord. Page number 1, paragraph number 2, last line, my lord. It is
Page number 1, paragraph 2, last line.
last line. It's recorded at 16 decimal. It should be recorded at 26 decimal, my lord. I have become
Where was
this is my written statement, my lord. In the
I am
schedule-
not talking about. This is
Order still there. Order copy done actually?
information.
No,
এখন তো আর বেরোচ্ছে না। Side করে।
this. You are a respondent number 1 or what?
I am a respondent number 1.
What do you say? It is a 26 or 16?
I have deeds. There are 3 deeds, my lord.
Sorry, let
my
us.
lord, I didn't. Just today morning, my lord, I get to know about
It has a larger impact. We will not.
it. For partition, my lord, the area is.
Because we have declared.
একবার দেখে নিন কালকে দে you will
To
also
verify it is a 16 decimal or 26 decimal.
I'll come for
Say 26, no difficulty. Otherwise, we will not.
let me check only this দেখে নিন আমি বলে দেবো কাজটা
You just consult the record,
yes
see to it. We are making it not today. Come tomorrow. Yes. Anybody knows Mr. Indrajit Mondal and Mr. Amit Banerjee? Can you inform him? We are just keeping the matter pass over. Dr. Indrajit Mondal.
Seven Malad. No. Seven Malad, I appear for the petitioner.
What is this?
Malad, is that matter your
Item
lordship
number
heard? Seven Malad.
7.
Malad,
It's the urgent determination.
Yes, Malad, your lordship heard
Wow.
this matter day before yesterday. Malad, with regard to that, Malad, your lordship has asked you for the state litigation policy with regard to resignation is concerned. Your lordship, day before yesterday, heard me out, my lord, heard both the parties, and your lordship directed my lord senior friend to produce the state legal litigation policy, as well as my lord.
Nothing is but from the other department, finance department have got something.
Use the audio system.
Pursuant to other directions, I'll inform the judicial secretary to supply me the copy of the policy of the state government. Litigation is concerned, but he informed that it will take some time. But so far as the finance department concerned, they informed, but if that each and every matter until the appeal procedure is exhausted, or there is a direction, one can see that. Which file has to be placed before the? I have given the 2 copies. And before filing an appeal, a lot of admission is necessary.
This is not a litigation policy. This is raising the financial concerns of the state government that in matters where their finance is involved, you exhaust the remedy of appeal. This has no application to the present. And the judicial secretary says he needs time to give you the litigation policy.
No. He looking into the matter because he was posted there very short time.
Unimaginable.
My lord,
I didn't have any experience, but my brother had an experience of the other state where the state has already adopted a litigation policy, as it appears. If a point which has been raised by the state has finally been decided, and there is also a due implementation thereof, then the policy should come from the state that in any matter where the same point is involved, the state would not take the same plea which has already been set at rest.
Futile litigation at the cost of the public exchequer.
There should be some uniformity, there should be some certainty in this regard. And the state has been saddled with the cost in some of the matters where the similar point is being taken.
and my lord, in that very judgment, my lord, your lordship, while my lord, passing the order, at my lord, internal page 6 of that very judgment, your lordship has practically said what the litigation policy should be. I'm reading it out. The ratio decidendi called out from the aforesaid decision is that state cannot reject the resignation tendered by the government employee even if the period falls short of period, provided there can compel such government employee to remain in service endlessly in perpetuity. Such being the ratio of the aforesaid decisions having been passed in the proceeding in which the state of West Bengal was a party, it is a matter of deep concern that the state continued to take the point which was negated in the said judgment endlessly in all subsequent proceedings. The certainty in law is a virtue.
Are you aware of the authorization under which the member is discharging the functions?
Yes. So that judgment has been given by the division bench of our High Court. This is the judgment delivered on 1st of March 2023.
No. We want to see the notification authorizing this gentleman to perform the duties in absence of a judicial member. And we had asked you to address us on the issue which emanates from section 5
Yes.
regarding the tribunal, constitution of the tribunal. Can there be a tribunal without a chairman?
Yes. Kindly see section 5 for the moment.
Yes, Administrative Tribunal Act. Who can
1985.
authorize?
Section 5.
Who can authorize?
Yeah.
Let us see. Section 5. Tell me.
Subsection 6. Have you already got it?
Subsection 6.
Subsection 6.
5 plus 6.
Notwithstanding any containing any foregoing provisions of the section, it shall be competent for the chairman or any member authorized by the chairman in this behalf function as a
So
bench
it is an authorization which should emanate from the chairman.
chairman.
No difficulty. What is the notification?
That notification mentioned in the order itself. Notification dated 2020. Notification dated 23rd December 2022. In the order itself,
December or November?
November.
23rd November 2022.
Yeah. Tell us. This is on the website. Who has authorized him? Tell us. Who has? Read. He himself has authorized him. He himself has authorized to act as a member, as a bench.
Is
Can he?
And prior to this notification of 23/11/22, is there any notification of designating him as an officiating chairperson?
I don't think so.
See, we had asked you to come with these issues. We are on the constitution of the tribunal. Whether it is a quorum non judice or not, that is the issue we are trying to consider.
Issue. But certain whatever
You are relying on this.
What?
You
Yeah.
have not produced this. You are relying on reference of this in the judgment. Now, please read it. This is from the website of the tribunal. Just see. Please hand it over to me. See page 2. Who has signed it?
signed gentleman who is officiating administrative member.
But look at the, he's an officiating administrative member. Who has signed the,
Yes, orders.
sir, who has signed? Second page.
Signed by the
Administrative member himself, authorizing to
Himself.
himself.
Yes, sir.
Self-authorization.
Can he? Is he a chairperson? No. He is a member who is authorized by the chairperson? No. Because there is no chairperson.
So again, we are asking you, is there any notification designating him as an officiating chairperson prior to him issuing?
That cannot be done. Because the qualification
Cannot
of the
be.
chairperson
He
is
cannot be.
it's a different
It
one.
is different.
Qualification says section 6,
Yes,
a person shall not be qualified for appointment as a chairperson unless he is or has been a judge of a high court.
yes.
Or a vice chairman for 2 years.
For vice about 2 years. No, so far as the new chairman is concerned, state government has taken every steps now filing with the.
No, we are not on that. That is alien to the issue which we are considering right now. The only point we had asked you to come prepared on is you raised an objection of his not exhausting the remedy under the Tribunals Act. We said, is it a quorum non judice today or is it a valid tribunal? This is the only query.
For a moment, the tribunal has no jurisdiction to dispose of the application because there is no constituted tribunal.
No, not assuming. We want to determine this issue.
Oh, yeah. But
Yes.
just give me 1 second.
Yes.
Now, then, what is the effect of section 28 of this act?
So we'll come to that. We can't jump to 28 without seeing 5. We can't jump to 28 without seeing 5. Everywhere, even section 28, see what it says. What is the term used? Tribunal.
Tribunal.
So only if the tribunal is there. You read 28, what does it say?
On and from the date from which the jurisdiction, powers and authority becomes exercisable under this act by a tribunal.
By a tribunal. Everywhere the expression is tribunal.
Tribunal.
So we are asking you, Is the tribunal in existence?
And 2011 Act, 21 Act, can you see that Act?
Sir, there is an act which says that certain specified classes of the cases shall be tried by a tribunal.
Yeah.
If the tribunal is not constituted, can a person be rendered remediless?
No,
Answer is no.
no,
So
To
they are
be just, ibi remedium. That principle maxim you know.
yes.
So if there is no tribunal as in the eye of law
Law.
as of date, then he has a right to approach the
The
other
High Court
forum.
before a single bench. Before a single bench under the appellate rule
Now, question,
or our High Court rule.
sir, that is what we are main issue is. First thing is because the tribunal is usurping its power on the basis of this particular notification issued by the member, administrative member, when
authorizing
section
himself.
5 says that it can only be issued by a chairman
Chairperson.
or a person authorized by the chairman. Can he do so? If he has done, then all these orders are a nullity. All these orders are a nullity. If it is a nullity, cannot the division bench say that it is a nullity? Is a wrong exercise of the forum, quorum non judice. Then if we set aside the order saying that tribunal is a denuded of power, then they will have to approach the single bench.
Yes.
But we have to declare. For that we wanted your assistance.
Yes.
Sure.
It was a very specific query. You had asked for 1 extra day. We granted you 1 extra day.
Kindly see, but
I think the advocate general will be able to.
in terms of the order passed by the division bench or High Court.
Can you send your junior? Not, we know you are very competent in this regard, no doubt about it. But I think the advocate general being the head of the state, he is representing. Can you tell your junior to just bring him? Because we wanted everything to be done. Because if we held, say that the tribunal cannot function with, then the tribunal has to be shut down.
Up down,
Yes.
closed down.
So that is why the advocate general has to come.
Why I informed the judge.
In fact, if we hold what we have to hold, we will just be performing the obsequies. It is not in existence to begin with.
But the division bench tribunal is functioning in terms of the order of the division bench of your lordship.
Oh, they are not functioning.
Well, can you see the order passed by your
So
lordship?
that is what I tell you. Again, suppose at that point of time, this particular matter was not brought to our notice. Or particularly, may I take the responsibility on myself that it was not. Can that order be said to be a correct if it is contrary to the statute? It is
Unless
absolutely a
this
per
is
injuriam
an
order.
issue raised and decided in those proceedings. Is it?
Yes.
Is the effect of section 5 decided in these proceedings?
No,
Then
but section 5 subsection 6 has been dealt with by
See,
I was under the impression it was not brought to my notice, if I correctly remember. It was not brought to my notice. Only thing is one other order which I correctly remember, if my memory does not betray me. There was another authorization prior to this.
no, Justice Pal
Which
authorized.
Justice Paul's
Already authorized
authorization was there.
this
It was
judgment.
brought to my notice, which was in conformity with section 5.
5.
But now, after this, Justice Paul retired.
Retired.
Then
And the
after this, what
vacancy
is
and 2023 vacancy has been notified.
then how an administrative member usurp the powers of the chairman
Tribunal.
and having an authorized person by the chairman? How
He
can
cannot authorize
many
himself.
issues, see, many issues arise. One is tribunal is defined in section 5. Can a tribunal exist without chairman? The second is a member administrative discharging quasi-judicial functions or exercising functions in a forum which has trappings of a court
Yes.
without a judicial member deciding issues. Does the scheme of the act permit this? That will be another question which
Yeah.
will arise.
Your lordship,
For-
correct, perfectly correct.
So, then how these things are functioning? And you're raising an objection that he is required to go there.
No, but because of the division bench judgment, there is a tribunal is functioning one
Please
member.
show from the judgment that it says that whatever may be said in section 5, this tribunal shall function or continue to function as it is.
In my assumption, the
Has to be read
tribunal
in the
is
context in which it was delivered. Not for every submission you can rely on this. administrative member is defined, judicial member is defined, the qualifications
Yes.
are defined, exclusion is defined, everything is defined. And one administrative member authorizes himself by a notification and he starts functioning and deciding cases.
And what Administrative Tribunal Act 2021 amended the Administrative Tribunal Act 1985.
Is this the amended provision that we are reading?
No, 2021
Yes.
been amended the Administrative Tribunal Act.
So this amendment, this
No, this not. The how
is
the
this
chairperson-
provision affected by the
No,
amendment?
no.
Then
How the chairpersons to be appointed or tribunal to be appointed.
that is not
That
the
is a
issue here,
new
sir.
law.
That is
That is
not
a
the
new law.
issue here. That is
I've
not
got
the
a copy of the notification issued by the Parliament.
That is not the issue.
Notified by the Central Government.
My lord, with the lordship
The
time-
issue we are considering will have a wide ramification if decided in a particular way.
Yeah.
If decided the other way, it perhaps be of no consequence.
You have not read it, then I am reading it for you. My brother was not there in my judgment. I have started with this. It is a sordid state of affair that the litigants have to approach the High Court for passing a direction upon the tribunal to conclude the hearing of the tribunal application pending before it over the years. While the instant writ petition was taken up, it was communicated to the court that the chairperson of the West Bengal Administrative Tribunal is no longer there as the tenure expired. It is really unfortunate that only one bench comprising of a chairperson and a member is manning the entire West Bengal Administrative Tribunal. And upon expiration of the tenure of either of the member, the matters are kept pending as there is some impediment of the part of the single member to continue while the hearing of the matters and dispose of this. Though the aforesaid observations have been made, but we are aware of the provisions contained in section 5(6) of the Administrative Tribunal Act of the Administrative Tribunal Act, where the chairperson or any member authorized by the chairperson may function as a bench consisting of a single member and exercise the jurisdiction, power, and authority of the tribunal in respect of such classes of the cases or such matters pertaining to such classes of the cases as the chairman may by general or special order specify. The proviso attached to the said provision creates a brindle in exercising the power, jurisdiction, and authority by the single bench in the event the said single bench found that the nature of the case requires consideration by a bench consisting of two members. Such power can also be traced from section 5(4) of the Act, where the chairman, I have said, chairman may pass a general or a specific order for the purpose of securing any case to be disposed of by any bench, provided in his opinion the nature of the questions involved therein requires the same to be heard by a division bench. The harmonious reading of the two provisions leaves no ambiguity in our mind that the chairman is bestowed with the power to issue general or special order in relation to such classes of cases to be heard by the single bench. But in the event the nature of the questions involved therein requires the same to be heard and disposed of by the division bench, such matter cannot be decided by the single bench. Ironically, the single bench may proceed with the hearing of the case, provided the questions raised therein do not involve complicated or complex question of law. In such event, it is to be decided by a division bench. Then say, the purpose of setting up the division bench is to minimize the error on meeting of the two judicial minds in pursuit of securing the just and timely justice. The complicated and complex questions of law, even involving the interpretation of the articles in the Constitution of India, require the consideration by the division bench of the tribunal. The formation of the opinion by a single judge is sine qua non to refer the matter to division bench, and such opinion must be recorded in writing in the judgment, indicating the complexity of the questions of law or the interpretation of the statutory as well as the constitutional provision. Mere relegating the matter to a division bench by passing a cryptic order is opposed to the statutory ethos and the provisions contained in the said act, as the opinion without having transcribed in writing is never regarded as a legal opinion. We showed our anguish to the situation. Only 3 bench consisting of 2 members have been sanctioned by the state government, despite the reality that the spate of litigations are pouring in the state administrative tribunal, and only 1 bench is grappling with the menace of the heap of the pending litigations, as there is no member appointed for other 2 benches. At that point of time, I believe it was there. I see. The Act does not put any fetter in sanctioning more than 1 bench. We thus do not find any fetter on the part of the single bench to continue with the matter pending before it, provided
Provided.
the nature of the case comes within the ambit of general or the special order issued by the chairman.
Chairman.
And in the event it is found that the complicated and complex, so we have said so. Sir, Mr. Advocate General, it's a very larger issue which has come. You are not there. In other matters, you are aware, I think in many of the matters we have flagged this issue. The State Administrative Tribunal is manned by a single administrative member when it consists of 3 benches. Consists of 3 benches, meaning thereby 2 members each in the bench. Now, it has appeared that the chairman is no longer there. Now, an administrative member is usurping the power and then deciding the cases. So we said under what authority an administrative member can function and decide the cause. Section 5 was placed before us. Section 5, no doubt, provides that a single member can act as a bench.
Subsection
But-
6 of section.
But subsection 6 says, but must be under the specific or general order of the chairman or a person authorized by the chairman.
By the chairman.
By the chairman. Now it appears there is one memorandum. Give it to him. Hey, this is on the website. You have
Yes, I have.
23rd November.
Yes.
Just turn the page.
See who is the
Who is
signatory.
the signatory?
Officiating chairperson.
Can he? He is not an officiating chairperson. Because to satisfy the eligibility criteria for the chairman, the first criteria is he is or has been the judge of the High Court.
Right.
Or was a vice chairman or
For
what-
2
what-
years. For 2 years.
what-
And a larger issue which arose day before yesterday. Please come to section 5(1).
That is what I was going to say.
Without chairman, is there any tribunal or it is all a quorum non judice?
Milord, may I say one thing, Milord? What I gather is, Milord, for appointment of the chairman of the tribunal, Milord, the committee must also be represented by the chairman of the tribunal. Now, since Milord, there is no tribunal, I mean chairman of the
what-
tribunal,
I could not get it. Committee must also be
Milord, the committee which is to select the chairman of this tribunal,
Correct.
one of the members of that committee has to be the
Outgoing
sitting chair-
chairman.
Yeah, or outgoing chairman. Now, Milord, since Milord, the chairman has retired,
Already gone
therefore,
out.
Milord, there is a difficulty in constituting the committee. I am told the matter was taken over by the Honorable Supreme Court. Supreme Court possibly has directed that in place of the chairman, since the chairman is not available, the Advocate General be made a member of that committee. This is an order which has been passed, Milord. I am yet to see that order, but this is what I have learned. Therefore, Milord, now, Milord, I think, Milord, if I am called, Milord, definitely, Milord, I'll try to, Milord, expedite things so that, Milord, the chairperson is appointed.
The issue.
There is
But
all-
so far as this issue is
But
concerned,
what the problem is, if the statute mandates a particular things to be done in a particular manner, if it is not, then it is virtually, we have to declare that the main entrance door of the state tribunal should be shut. Then we'll have to think of.
yes, Milord,
But the ultimate result would be, if we say that it is a bad for quorum non judice, then there cannot be any functioning of the administrative tribunal till the committee decides to appoint the chairman and the other members of the tribunal.
Milord, what I have been handed over right now,
Yes.
Milord, is a notification of 12th of September 22, which says that the governor is pleased to appoint Sri Shahid Ahmed Baba, administrative member, West Bengal Administrative Tribunal, to officiate as chairperson of the West Bengal Administrative Tribunal under Rule 7D of the Tribunal Conditions of Service Rules 2020 something, not very readable.
Where is that? Where is that?
Until it's very, Millard, এটা কার phone? Yeah? আপনার phone. Your Lordship may have it, Millard, from Mr. Mukherjee's. This is the room.
Where is
I have a
that?
printout.
Yes, we'll hand over, Millard. Just now, Millard, I'm.
And the copy of the rule.
Please put your thumb impression.
Hey, কার phone দাও?
বন্ধ হয়ে
দিয়ে
This
দাও,
is Mr. Mukherjee's phone. You can understand.
দিয়ে দাও, বন্ধ হয়ে গেছে।
খুলে দিন আমি বললাম
ওরা তো লুকোনো কি আছে যে লক করো? এই খুলেছি।
this is under which provision? 7D.
7D
Can
of
we
the
see,
rules.
can you please place that provision?
এই রুলসটা রুলসটা এই রুলসটা কোথায় দিচ্ছি?
7D is not here in this. 7C. And there is no 7D. 2021 rules.
21 rules.
This
Rules are what I
is on the basis of this tribunal reforms and procedural which I used. And the central government.
তুমি রুলসটা দাও না, রুলসটা ছিল তো তোমার হাতে।
Where is the 7D? Case of a tribunal that will be sued, the person shall not be qualified for as chairman or cannot or has a period of not more strictly known to judicial members. This is politician. In the central administration.
এই বইয়ে তো রুলস নেই।
Administrative member or
স্টেট রুলস তো।
No, no, no.
এই যে ট্রাইব্যুনাল কন্ডিশনস অফ সার্ভিস রুলস 2021 না কত দেখা যাচ্ছে, এটা কি স্টেট রুল না
Sir, also there is a difficulty in this rules. This rules, the difficulty is, you said 7D. 7D is not there in these rules. It ends with 7C. No, no, he was referring to this, the Tribunal Condition of Service Rules 2021.
Yes,
You are referring that.
yes.
So 7D is not there. If you come to 3, 5,
But I don't have a copy of that rule. Please give me a
we have been given a just printout.
We have 2 copies. You please take
You take one. Ye dao, take one. Look at 3, 5. Rule 3, sub rule 5.
Yes,
Please, qualification. What?
right.
Shall not be qualified, negative, as chairman unless he is the judge of the High Court or has been, and the second is also there.
Yes,
3 years continuous period as an administrative member or a judicial member, where in a central administrative tribunal, not a state.
right.
And this gentleman does not qualify either of the conditions. Can he officiate as a chairman? Look at the technology, Mr. Advocate General. You have given a WhatsApp, immediately the printout has come. The advantage of technology.
Milord, 7C, kindly have a look.
The governor speaks to appoint such and such administrative to officiate the chair.
But your lordships may kindly have a look too.
7D is not there.
7C, Milord, page
Not,
22.
it's not, it talks about 7D, but 7D is not there. Even if we say 7C,
No, no, এটা না।
7C is regarding technical member.
Again, where I've handed up to the court, Millard.
no,
Sorry. দুটার নাম কি?
And this notification, this order is issued under 7D.
But,
look at the
top,
printout. You
page
have the
22
printout?
22 of that notification, kindly see the last line. At the top left-hand side, your lordship would find, my lord, page number.
Will take effect from the date of demitting the office of some judicial member, officiating chairperson of the tribunal.
That's,
Miss Urmila Dotto.
yes.
My lord, if your lordship allows me, my lord, on 26th of August 2022, my lord Justice Soumitra Pal retired as chairman. But thereafter,
And page
Urmila Dotto
22
was there till
perhaps, Mr.
22nd of
Advocate General, is
November.
regarding the Green Tribunal.
At the bottom, my lord, any vacancy in the state administrative tribunal, the governor may appoint one of the members to officiate.
Where? We are,
That, I just, if I may get back, my lord, once more, my lord.
casual vacancy.
Yes, yes. Under casual vacancy, the last one on that page.
Tribunal with the debt. Should the tribunal take a possibility?
No, you will see, just have a look at it from this point. This is part of section 7.
Yes,
Now, after 7,
yes, my lord.
every different tribunal is dealt with in every different sub-clause.
Right, my lord.
Now, this what you are referring to is part of the clause which starts for Green Tribunal.
Yes. But this is what, my lord, appears to have been.
Please see page 21, 15, clause 15 at page 21.
Chairperson of the Detrica.
Or 7D, casual vacancy 7D.
Yes.
So does this means that the notification can be issued divorce the qualification prescribed in the main statute?
This, in my very respectful submission, my lord, are stopgap measures.
No, even for stopgap, would it mean that it will be divorce the qualification required of a chairperson? Or that has to be read as part of this?
Shouldn't be. That cannot be read, because if I am not a judge, through interpretation, I cannot be made a judge.
Therefore, that will. No doubt there is a power under this, but it cannot be divorce the provisions contained in the statute
Yes.
which prescribes the qualification.
Right. But this appears to be, my lord, central rule. This is framed, I find, my lord, under the.
So we are saying it cannot rise higher than its source. It is under 36 of the Act.
Right.
And an objection is being raised that unless they exhaust the remedy before this tribunal, they shall not be here. Over a trivial dispute, we had also asked the learned counsel who is appearing to inform us whether there is any such thing as a state litigation policy in existence. Around
Because the-
2011-12, all states have adopted a litigation policy. One of the salient features of the policy is not to pursue futile litigation where points have already been decided. Whether a person is entitled to acceptance of his resignation simplister, which entails forfeiture of his past service, or the government can say that no, in public interest you have to continue. Issues settled by his lordship's judgment again re-agitated in the same manner in these proceedings.
But
And
I
due
take up the question.
implementation, Mr. Advocate General, the due implementation has also been made. And in one of the litigations, the bench to which I was also one of the member, we have imposed cost against the government. That this kind of a futile litigations, taking same plea one after another, when the court has constantly decided that point against the state, this is a real wastage of the court's time. And we have imposed a cost of rupees 50,000 against the state. Again, when the third matter came, or this matter, same plea, same thing. Only thing is, with the change of the counsels, the change of expressions and the language comes, but the bottom line is the same point. Nothing more than that. One uses a flowery English, one uses a very plain English, but they aimed at the same point. So why not? That's why, my brother, I was not aware of this particular policy decision of the other state. And it appears to be a very sound and very, I would say, logical policy that should come. Unnecessarily, litigation should not be
Right.
there, and the court should not be burdened. Just repletion of what has been said earlier. And every time the imposition, the court is a public exchequer.
Right.
And the persons are not responsible. Henceforth, we will say the person who is giving an instruction will be held responsible, deduct this amount, which we have directed from a public payment, from a public exchequer, from his salary.
Unless it is an error of judgment.
No,
Then
that's
it
why
would
I'm saying,
you would have gone in appeal.
if a point is decided, the state has challenged this order before the appellate court. Not if the appellate court has affirmed the order. The state chose either to go to the Supreme Court or not to go to the Supreme Court. If the state chose not to go to the Supreme Court, means the state has accepted that particular proposition. Then in a subsequent litigation with a change of counsel, this was not argued, this was not argued, and then inviting the same thing to be done. Can it perpetually go on? There should be an end.
Right.
Engagement of the various lawyers from the panel, scrutiny of their bills when they submit. I have closed the audio system. Verification.
Two matters.
My state has preferred, I must say, my lord, in terms of 2016 order passed by my lord Justice Nishita Matre and my lord Justice Taposh Mukherjee, if I'm not wrong. The state has moved these, filed an SLP before the Honorable Court. My lord, at the initiation, my lord, state has withdrawn the SLP. There is annexed, my lord, page 90. And my lord, thereafter, your lordship's order, my lord Justice Sanjeev Banerjee's order, my lord Justice R.P. Mukherjee's order, all the order inconsistency, there is no departure. But still the state is persisting on this, my lord.
Yes, sir.
The point is very simple. Person has completed all the body and later on the politics is done. He being person of the better. Suppose this is not a conscious state appears to be jealous. Suppose if you want to decide and want to set up a I want to know ground of public interest. Is it not a public interest? Right to trade profession, a fundamental. If they want to start their own practice, the profession they want.
But I'll look into the, at least this matter.
The thing is, I am first, we are not unaware of the things that are because it is a larger object with every year you have got a lot of medical problems. It's the number of the medical problems by the passage of time. And we were the student, how many medical problems we had now?
14 only total 14.
If I am not wrong, 5 to 7. Now,
NRS medical তখন ছিল NRS medical
Same with the law colleges.
আমাদের সময় চারটে ছিল when we passed my lord, my letter series is much more senior, your lordship may not be saying my lord in 2000 well, 2002 my lord I passed out, there were 4 colleges in Kolkata. Now my lord I do not know, might be 400.
Yes.
There were 4 colleges, man.
Yes, Mr. Mukherjee, তোমার কত হলো?
College একটা Mohsin, or there are 4 law colleges in Kolkata, one in Mohsin, one in North Bengal.
Calcutta University and Harvard University are not so.
I will not give a what it does not want to give a
ক বছর চাকরি করেছিস? 9 বছর, 5 বছরের একটা ক্যাপ আছে।
Also, test 27 I am undertaking this. Test 27 also undertaking this.
But I'll look into it and come back.
Test 20
But I'll ensure that his grievances are resolved.
yeah.
One
Please,
বছর
sir,
হবে।
you know.
Give me 2 days, brother.
Assistant professor
That is-
কবে মধ্যে জয়েন করতে হবে?
30 extended করেছে 30
30
এপ্রিল।
But my learned friend says that he has time till 30th.
I think here, I would say it's persuaded to extend the time because of the litigation.
Right.
He's also correct. Because though there were an order passed with him, they will permit him to join subject to the result. Their grievance is also genuine.
Right.
Suppose if it is there, ultimately the writ petition is decided against him, then we will be absolutely in futility. Every exercise will go in futility. So they wanted a certainty so that he may continue for a longer period.
But I'll come back on Monday, Milord. I'll ensure that.
Monday is again,
29
today is
Actually, I'll come back on Friday, day after tomorrow.
my lord, if that be let that be part heard tomorrow, my lord, let that be part heard, my lord.
Part heard হোক না, অসুবিধা কি?
Part heard হোক।
against my principle.
My lord, the problem is this, my lord.
My principle.
My lord, let my
Against my principle.
It is, I think it is.
It's not a necessary.
Your lordship asked the matter and like
So, but it was urgent determination.
My lord, your lordship kindly take note, my lord, this bench is having determination till today, my lord. From tomorrow, as per the list cause list, my lord, just Tapaputra Chakravarti will have the determination. Now, my lord, again, I will be in soup, my lord. Your lordship is hearing out, let that be a second half. It's only question, my lord, I have tendered more than 9 years of service.
Come at 2. When
Come
he
at-
is there, come at 2.
Then keep it Milord, as the last item today. If there is a 3:30 before last item at 3:30 or 4:30.
Health, DME, sir. Sir,
না, ট্রাইব্যুনাল দরকার নেই।
Sir.
এই ছেড়ে দিলে কি
sir, একটা extra আছে স্যার আমরা।
অন্য ইস্যু মনে করবো
তুই আমাদের যে পাতাগুলো দেখতে হবে একটু উপরে না, ওই যেটা যে অর্ডারটা দিতে হবে
কে আমার চেম্বারে পাঠাবেন?
আমি যেমন উপরে
But I'll come back now at the end of it.
So I appear, my lord, in this matter, my lord, I am appearing on behalf of the District Primary School Council, Paschim Medinipur, my lord. I am appearing for the District Primary School Council, Paschim Medinipur. My lord, in this matter, my lord, prior to my lord starting the matter,
Yes,
my lord, in connection with this matter, my lord, one judgment was passed by your lordship, which was thereafter, my lord, appeal was preferred. And my lord, on the basis of the judgment passed in the said appeal, some, my lord, orders passed by the, my lord, the Commissioner of School Education. And thereafter, my lord, it was implemented. Therefore, my lord,
allow
this
me to
should be,
place?
this should be firstly,
It will be
my
easier
lord,
for everybody.
submit before your lordship, because of that in earlier occasion, several appeals were filed in connection with other matters, my lord, in this procedure, recruitment procedure. Thereafter, your lordship was pleased to release all these matters. Therefore, my humble submission before you to kindly peruse this one, and thereafter, my lord, kindly take
hear me.
decision.
Kindly hear me for a minute. My lordship, kindly hear me for 2
And my
minutes.
lord,
This was taken up.
Yesterday evening, notice was served upon me.
No. It's absolute.
4 p.m. At 4 p.m. What are you telling? I have not said so. Your lordship kindly consider it. My lord,
This was taken up by my Lord Justice Prasad took up the matter. There were some defects, and we cured the defects. On the kindly hear me for 2 minutes. Thereafter, if your lordship. No, the difficulty is why this point is being taken up. Why this point is being taken up? Kindly hear me for 2 minutes. No, this is not being the. This is no state. This has no relation with the lordship's order. No. There has to be a cogent reason why.
And my lord,
There has to be a cogent reason why.
matter also.
Why this point is being taken up.
Hey.
Lordship is
Of maintaining consistency, since my lord has not heard any of the matters, he will not be hearing this matter. We are not on merit.
no relation. This is no cogent. If somebody is so,
Itself,
this is becoming a.
it is, I have submitted. Your lordship can take up the matter. I have no.
No, now let's see.
But my lord, I have. It is my.
Kindly see this.
Yes.
You cannot.
How can you oscillate
not a-
between two extremes?
My
This
lord.
is very
No,
peculiar.
I have not
You have
exchanged.
raised
Yes.
and Sorry,
Stand by it. Once you have raised it, stand by it.
Now illegal appointments are regularly being scrapped. Therefore, the choice of bench is becoming in the scenario.
anyhow.
This is absolutely horrible.
Sir, this is only the urgent determination.
The urgent determination, the person's enjoying our fruit of labor for years.
This matter has been filed in
For
the,
one day, nothing is going to happen, nor a heaven is going to fall. Nothing.
in the month of January.
No, difficulty
In
is
the month
this.
of January, this
Whenever
matter was
the
filed.
matter is being
It was never
posted,
mentioned before
on the other day,
regular bench.
this was taken up by Lordship Prasad, your Lordship.
We are not recording anything on that. Anyhow,
If it thinks so that
the request.
and the difficulty is this, Lordship is having determination till today. Suppose Lordship is getting the determination of tomorrow, I'll be in a soup.
Every judge understand. When we made a request, he will understand that what request means. Don't worry.
This is absolutely unfair. This
Yeah. So that's why we recorded.
absolutely unfair.
Item number 9, Malad, I'm appearing for the. Okay, this is
Really hard, sir.
Is 9.
Malad, in item number 9, Malad, I'm appearing for the appellant, Malad.
Yes.
May I please, Your Lordship?
Why? What is the urgency which cannot wait till tomorrow?
Because, my lord, time is running, my lord. This matter regarding to the,
By the regular bench.
my lord, though, my lord, the university, Baba Saheb Ambedkar University is the main respondent in this matter. I don't know why they choose not to appear, my lord,
This is what I was just thinking because
but I served copy upon them,
let
my
it
lord,
be-
physically.
let it be taken up tomorrow by the regular bench. No difficulty.
Then, my lord,
Discussion.
then, my lord, some direction be given so that the file can go before court number.
They will send it.
Yes, my lord. Then, in the meantime, I can serve a copy upon them.
There is no appearance on behalf of the respondents. Then the regular bench should be available for tomorrow. Let this matter be listed before the regular bench. Yes, call. What for orders? Nobody's here. For orders, the other side, no arguing counsel.
Orders is
Please ensure his presence so that in his presence we can fix a particular date. This is that matter, municipal magistrate. Catch hold of him, tell us at 2 p.m. we will fix a date. It's a point of reference we have to decide. Yes, call the next.
Well, my lord, I am for the petition. My lord, I am led by Mr.
Appearing for the respondent state, my lord.
Respondent state.
State.
Yes, my lord, the petitioner before your lordship was a associate professor of the Institute of Psychiatry. My lord, I am led by Mr. Basu.
No, you can. Here below the order of dismissal, Millard, we have challenged the passed by the 7/3/2024. Millard, my status is Millard, so far as the Millard first is contractual employee. Now, Millard, it is a dismissed employee. At present, dismissed employee. Now, Millard, interim order, Millard, as that was granted, which I had shown, Millard, on 19th September 2022, at page 176, Millard, 76. (176). Yes. Now, Millard, 2 points, Millard, are subject to correction, Millard, are required to be considered by lordships. With deepest humility, I am submitting that even if I am a contractual employee, the government had, my lord was kind enough to ask me that where is that memo? Your lordship was on the last occasion, Millard, I am armed with that memo. This is the first memo. Based on which, Millard, the interim order was granted, that the government had extended this service of the contractual employees, Millard, till 60 years. And, Millard, there are certain grounds on which, Millard, the service of the employee, contractual employee, could be terminated. Millard, first memo was issued on 16 September 2011. Thereafter, Millard, 16. I am opinion. The first paragraph, may I read for my lords? In order to provide security of tenure, appropriate emoluments, and certain terminal benefits, subject to fulfillment of certain conditions to the casual delegated contractual workers who have remained engaged in various government establishments for a considerable period of more than 10 years in connection with the implementation of various schemes, projects of various departments of the government, memorandum such and such were issued by the government in finance department. The question of making the provisions of the two aforesaid orders more effective and suitable to the convenience of the government establishment organization has been under active consideration of the government for some time past. Now, Millard, then kindly comes to Millard, Roman 1, the casual delegated contractual workers who have rendered 10 years of service continuously with at least 240 days attendance each year may remain engaged in the same status and capacity till their attaining age of 60 years. Then, my lord, kindly comes to my lord that I'm sorry. This is, my lord, the clause 10, it says the provision of this order will not be applicable where contractual engagement has been made without any sanction post for any specific project for a very temporary period up to maximum 6 years or 11, sorry, my lord. During the period of engagement, the service of casual delegated contractual worker may be terminated because of involvement in criminal case, misconduct, delinquency, incapacitation, etc., or if the concerned worker intends to opt out of the engagement on his or own. Now, my lord were kind enough to ask me on the last occasion, what is this memo was revised on 25th February 2016. On the basis of this memo, Miller, the interim order was granted and it was considered by the Honorable Tribunal. In this department number such and such dated 16/9/2011, it was decided to allow appropriate emoluments, security of tenure and certain terminal benefits to the casual, delegated, contractual workers subject to fulfillment of conditions therein. The matter regarding improvement of monthly remuneration, annual increase, medical facility, leave and other benefits as well as a review of the conditions of engagement were under active consideration of the government for some time past. Now, after careful consideration of the matter, the governor has been pleased to decide to revise the benefits as follows. All contractual, casual, all contractual, then / casual, delegated workers shall continue to be in engagement up to the age of 16 years or years. Engagement of contractual / casual delegated workers shall not be terminated except as prescribed in the above referred memo. Now, my lord, this is 16/9/21, which I have shown to my lord at the outset.
So
Then,
according to section, this subclause 11, at the last page of this
my lord, 2011.
You say your status has now improved.
Yes, my status has now improved and I mean, protection has been granted, except in the cases mentioned therein, my lord, I cannot terminate it. I cannot be. Now, my lord, the question is, my lord, that it is a sanction post when the advertisement was issued. Number one. Number two, my lord, I was appointed as a I was given headship. During, my lord, the tenure of my extension, my lord, suddenly, my lord, there were 4 successive inquiry committee. I attended each and every inquiry committee on the basis of the allegation made by the students. I was denied, my lord, my right to cross-examine. My lord, no natural justice. I said, my lord, at least I have a right to defend. My lord, it was...
In 2011, you had put in how many years of service?
My lord, I was appointed at 2016.
No, in 2011.
Yes, in 2000, my lord, 2015, my lord, that is the joining.
Your joining is in 15.
15. My lord, kindly sees that I joined the institute on 27th April 2015 at paragraph 4, page 3 of the writ application.
So how will you be covered by this 2011 memorandum?
No, 2016. The interim order was granted. The journey starts from 2011.
2016 finds its roots in this 16/9/2011.
No, it says, my lord, initially.
See clause 1.
Yes, yes. But it says, my lord, there is a 3(1) applies to me. It says all contractual.
Sir Basu, please, the opening line.
In this department dated such and such, it was decided to allow appropriate emolument, security of tenure such and such to the casual daily.
So this is rooted in this 2011 memorandum.
Right.
You were not in existence.
I was not. Paragraph number
2011 apparently seems to be an exercise in terms of Uma Devi because it's a one-time exercise.
Yes, paragraph 53.
10 years.
I'm extremely grateful.
40 days. So
yes,
you are
yes.
not part of this.
No dispute.
Can you?
No. I can, my lord, subject to correction to be made by the matter regarding improvement of monthly remuneration, annual increase, medical facility, leave and other benefits, as well as review of the conditions of engagement were active under consideration of the government for some time past.
Sometime when you were not in existence.
I was not in existence.
For
No,
those
I was.
people who had worked
For
for
the-
more than 10 years.
February to April 2015, I was there. This memo was issued on 25th February 2016. I was very much in the establishment. My appointment at page 40, paragraph 4, page 4, Millard, clearly indicates my appointment was 27th April 2015. This memo was issued, Millard, 25th February 2016. This was in modification of this, and the government has, Millard, had taken note of, Millard, this existing condition of the all contractual employees. Now, Millard, without any differentiation. So, Millard, it gives a clear indication that I was sufficiently protected by a welfare state, Millard, the mentality of it, Millard, reflected from this order.
You see the 2011 memorandum.
My lord,
Other says don't continue to make such engagements.
right.
And your engagement is after issuance of this 2011.
I'm extremely grateful, Millard. I'm extremely grateful.
So
But I have
whether
also, Millard, read.
part of the transaction which is covered by this memorandum,
Millard,
or you form
Millard,
a separate class.
Millard, I am not a separate class subject to correction because there is a language. This memo will not be applicable where, Millard, the appointments were made not against a sanction post. In my case, Millard, this is a sanction post.
That
First
has
of
to
all,
be read as a whole in terms of
Millard,
Devi's
in the
judgments.
context of the, it rooted through, Millard.
Sanction post procedure in accordance with the
Yes,
constitution.
this applies to me.
10 years without any order of the court. All these things are dealt with in this memorandum.
Millard, the memorandum. Now, Millard, this in that
And
memorandum,
this memorandum is founded on that only.
Millard, subject to correction, Millard, I can pursue, Millard, this judicial mind by saying, subject to correction, that 2011 did not take into account my condition because I was not born in the office. So, Millard rightly said, 2015 April, Millard, I was, Millard, engaged. Millard, as against the sanction post, interview was conducted, written and all things. Now, Millard, the question is, Millard, that even if I Millard, assuming, not admitting, Millard, but 2016, 25th February, it takes note of my existence because I entered the service on 2015 April as against the sanction post.
Where does this take notice
Because-
of your existence?
because, Millard,
It does not.
Because, Millard, subject to correction, because this now after careful consideration, 2011 imposed certain condition.
As it appears, prima facie, you have come in much after the 2011 memorandum, which
No doubt,
appears to be a one-time exercise in terms of Secretary of State
no
of
doubt,
Karnataka.
no doubt, no doubt. But
So-
2016 government wants to, Millard, modify. Government
Modify what?
modify,
What is
Millard,
mentioned in the first line?
First line. Now,
Correct.
Millard, the government did not say the word, Millard, in a sentence. All contractual, which includes me, this was not there.
Has to be read in the context in which the memorandum
Millard-
is drawn up. It does not mean future, prospective.
Millard,
It will have to be read in
Millard-
the context in which
Millard,
it is issued.
Millard,
Not
25th,
otherwise.
File the opposition, because these are the very larger issues that has to be.
and Millard, subject to correction, Millard, even if I am a contractual employee, prima facie, if your lordship is not satisfied with the memorandum, the applicability of the memorandum in my case, Millard, I am armed with the 2 Supreme Court judgment, which says even if the status is the contractual, when there is an allegation, which is not even motive but the foundation of, Millard, dismissal, even then, Millard, inquiry is necessary.
Lifting the veil is a different thing. Whether we will lift the
No,
veil, will be
no,
required
right,
to lift
right,
the veil or
right.
not. That is a different thing. But the order appears to be an order simplistic.
The
Neither
order,
any stigma is attached, nor there is reference to what you were saying.
Millard, attending circumstance is a very important word.
As his lordship has said, let them
But,
file.
Millard, in the meantime, if they appoint someone, Millard, the tribunal while, Millard, otherwise, Millard, I was all along there. I was enjoining interim order. Interim order was never questioned by the state. State, Millard, accepted. State never accepted the,
File it soon. He has been having the cover of the
Let's bring
interim.
affidavits.
When?
Affidavits on opposition and exchange. My lord,
1 week.
question of
Just file it
interim
within a week.
application
we'll
does
make-
not arise, my lord. Please come to the order of the tribunal. I will file within a week, 2 weeks.
Then file it.
2 weeks. My lord, 2 weeks.
1 week. We want to expedite the matter.
My. Kindly come to the order of the tribunal.
What it says? What it says?
কি বলতে
My lord,
চাইছে?
in terms of such appointment, the applicant signed agreement with the respondent. She had agreed to all the terms and conditions, and she was appointed on purely contractual basis. My learned friend,
Where is the
the
dispute
debate
on?
of his
Madam,
submission,
Madam,
it is
he
not a sanctioned post.
He's not disputing that his appointment is not contractual. He's not
She,
disputing.
writ petitioner is not a
do not
sanctioned
know.
post,
I do not
not
know.
holding a sanctioned post.
Now question is, he's raising up or flagging an issue that this appointment on a contractual basis was against a sanctioned post. Whether it is against a sanctioned post or not against a sanctioned post is a matter to be decided on an exchange of evidence.
It was not a
Secondly,
sanctioned post.
he wanted to take advantage of 2011 and 16 circulars or the notification. Whether those notifications or the circulars have any kind of a link to his appointment is also a big issue. Yeah. Your question to some extent accepts
Not within 2 weeks. My lord, 2 weeks. Message to your lordship, my lord. 2-3 years past the order and now he has come up with this application. I think already in regular manner, casual manner, already employer taken the appointment of the employee. 2 weeks. I bow down to your message, lordship, but one thing, 2 weeks. My lord, today is Tuesday, my lord. Wednesday today, so fortnight.
Millet protection, millet, some protection, millet.
Protection, my lord, there is no question of
Millet, millet, I was enjoying.
Then let me hear.
Yes. Interim order before the tribunal.
2-3 years ago,
Not
no
there.
protection.
Very bad case. The respondent took up the task. The bench said, "Is over. We have heard you. Appeal is admitted." Who has suffered? Though I do not agree, because it is a litigant who suffers ultimately. But there the days.
Millet, only.
I beg your
So
pardon.
it is not advisable.
Millet, only millet, I was enjoying the
It will be extracted from you and may go against you.
millet, I was enjoying the interim order. Government did not challenge.
Interim order, my lord.
Government did not
Tribunal
challenge,
did
millet.
not pass any interim order.
Only millet,
Can
not to
vacate it, your lordship.
contested.
You have any
Contested.
instructions that any steps have been taken for appointment on that post?
Appointment, I think 2-3 years ago, and so already appointed.
Already appointed.
Yes,
What are you
my
talking?
lord.
Interim order. I was enjoying interim order 7th March. 7th March.
Tribunal, how tribunal? Findings of the
Madam,
tribunal,
no.
my lord.
This order appears to have been passed recently.
7th March.
The interim order was operative till the day of.
Yes, 19th September
But the
2022.
findings of the order of, my lord, come to the order of the 7/3/24.
Yeah.
We are recording.
My lord, 7/3/24.
Yes.
Kindly see.
Lord, we are the respondent. Lord, writ proceedings were disposed of in our favor. The learned judge directed refund of registration fees and land licensing fees, which we were compelled to pay to the railways. 19.5 crore is stuck, Lord. 10 crore on account of Lord registration fees and 9.5 crores on account of land licensing fees, which they had taken extra. The order is to refund the money to us. Lord, the appeal is before your lordship, Lord.
I am for the appellant, my lord. May I be allowed to join virtually, my lord, today?
Why not? We always encourage. Don't worry. We always encourage the virtual appearance.
My lord, the scope of appeal, my lord, is very limited, as my learned friend appearing for the respondent has said, my lord, that it is a question of refund of money in a writ proceedings. Now, my lord, kindly, before we show the impugned order, my lord, kindly take 3 admitted position that if there is a dispute between the parties regarding the entitlement of the money, then, my lord, usually the writ court doesn't interfere because there is an arbitration proceedings. There is an arbitration agreement between the parties, and if there is a dispute, usually it goes to arbitration. Now, my lord, the saying so, the basis of the judgment is an admission. Now, my lord, they say that the railways have admitted this amount of money. Now, my lord, it is the contention of us, my lord. There are 2 scenarios. One is, my lord, the land licensing fees, and one is the registration fees. Now, in respect of the registration fees, my lord, our short point is that yes, there is an overpayment, but this needs to be adjusted from the loading of the party, because when you pay registration fees, you pay for a particular siding. This is our point. So for that siding, if you have paid a registration fees, which is a sum of rupees, whatever the sum is, 10 lakhs or 10 crores, that needs to be refunded. How it will be refunded? Because you will be loading from the siding, and, my lord, from that 10%, gradually it will be refunded. Now, the honorable judge, my lord, with all humility, has said, no, once you've admitted, you have to refund it immediately. And not only that, my lord, interest was also imposed. This is first. Second, so far as the land licensing fees are concerned, my lord, the letter of admission, I will show, my lord, clearly says that it will be adjusted. The specific words are, my lord, it will be adjusted. It will be adjusted with the refundable amount. So, how it will be adjusted, my lord? The excess of land licensing fees will be adjusted from the land licensing amount which is due and payable every year. This was our contention. Now, the honorable judge, with all humility, I submit, my lord, has taken a part of the admission. No, this is the admission, and the modus of refund is what I decide. So the dispute, my lord, is of very limited nature. That in view of the admission, whether the way the railways wanted to refund, that's the only way available to the railways, whether that is acceptable or not. Now, my lord, in this context, my lord, kindly now come to the impugned order, which is at page 378.
Unqualified by the railways, so far as the registration fees is concerned.
Sorry, my lord.
Can you show us this letter which has been relied upon by the single bench?
Yes.
That
can we come to 452?
There has been a letter was produced by the railway pursuant to the order dated 4th February. Can you show that letter?
Yes. My lord, kindly come to page 452.
Was it heard by some other bench?
My lord, yes. Initially it was heard by a different bench, my lord. The arguments
Why
took
the matter
place.
has come up before us?
I don't know that, my lord, because my learned friend has mentioned the matters couple of times from the respondent
You
side.
have the determination now, my lord.
Yes,
Your lordships have the determination now.
it's a group 7 matter.
Yes, yes.
Group 7 আমাদের কাছে আছে।
It was heard by the bench presided over by Lord Justice I.P. Mukherjee. That at that stage, his lordship's notings are there.
That's why I asked this question.
3
It
to 4
appears from the record.
Yes, my lord. Substantial hearing took place, my lord, before the.
If the substantial hearing has been done by the other bench, then why can't this matter be released so that the matter can be decided there?
Lord, Mr.
So that lot of notings that
Roy
has come,
did
I do
commence
not
his
know.
arguments, but
Inci-
we never had-
Incidentally or accidentally, this is there in the paper book.
Lord, we will be running from pillar to post to Lord, to get it heard, Lord. Lord, so far, no. Lord, Lord, so far as the hearing is concerned, I think at one stage his lordship directed filing of paper books. After paper
No,
books,
there
I
is a
don't know.
lot of
whether-
notings there.
No, that's right, Lord. Mr. Roy did commence his arguments on the basis of the stay application, but his lordship's directed that paper book should be filed. After that, perhaps no hearing took place. And we've not had a chance of hearing. Mr. Roy did commence arguments, no doubt about that. I think 2-3 days hearings did take place. Thereafter, paper books were directed to be filed. But his lordship now has. The difficulty is that his lordships now have the original side very heavy bench, Lord. It will be very difficult to get it heard.
After all, when a bench has applied its mind,
Lord, 2 years back, if your lordship sees your lordships,
has heard the matter,
no doubt about that. But if your lordship sees the
which is also evident from whatever.
No, even on the order sheet that may be there. But if your lordship sees,
It's not an order sheet in that sense.
perhaps not last time it was taken up effectively was in December 2022. So, my lord, 1.5 years have passed. Their lordships would also be hearing it as virtually a new matter.
Let me find the date also here. 5/12/2022.
1.5 years have passed after that. We are really trying our level best. Some of the other
And it
to
was
ensure that
also
the
on
appeals are heard.
6/12/2022. Two dates are there.
Now, Lord, it will be very difficult for us to get it listed, heard, because the entire original side, the appeals are now there, Lord. Lord, whenever your lordships are find it convenient, Lord, please fix any day whenever your lordships are convenient. I understand your lordships,
Every
Lord.
day is convenient
Yes.
to us. So far as the hearing of the matters and disposal thereof, it's every day convenient. We don't think any other day, but whatever, accidentally we could get some papers here.
Do your lordships get those pads? His lordship's personal pad. It's not that your lordships are. I hope there's no other matter also noted there, which his lordship may be missing.
Normally it does not come, which shows that there was an application of mind by the other side.
Yes.
And there is a lot of notings which has been done on 2 days. Though we can't decipher anything therefrom, but still. And very first noting is page 452.
But Mr. Roy also candidly says it won't take much time. It's a matter of construing the admission. But our clients are in great difficulty. A lot of money is stuck, and lot of money is stuck in 19.5 crore. The railways are sitting with the money, my lord. And
No, Malad, this is not probably right, Malad. I have not interrupted my learned friend, but to allege, Malad, we wanted to refund them. But they said that no, you have to refund it in the manner I want.
Correct. Once liability is established, they can't say we will pay you
No,
over
no,
10
that-
years, 20 years from
No,
this
not
siding,
that,
that
Malad.
siding.
Not that. They,
There is
there's
an
a lot to
admitted
say.
liability which they admit
There
in
is
the
a,
letter.
Mr. Sen,
That is so the
in his
refund
own
is entitled
fairness,
to pass an order.
will agree, Malad, there is a lot to say here. It's not a very short matter. Because we have to submit, Malad, why railway is saying this, whether it is reasonable or not, and if it is reasonable, usually a REIT code doesn't interfere. By directing, Malad, not only payment, but with interest. Usually, Malad, REIT codes usually don't interfere like this.
Not confused.
But if your lordships release it, when we'll again get this chance, Lord, it is really not unknown. Their lordships are a very heavy bench. And Lord, 1.5 years has passed. Not that their lordships would, of course, their lordships would have a faint recollection, but the details would not be not known. It'll be as if it's new matter is being heard anew in any event, Lord, whether there or here. We are in your lordship's hands, whatever your lordships decide. But
Yes. The refund amount. Refund. Refundable amount. Refundable. Some. It's the dash of this. Pursuant to this decision. This is
Yes, yes.
My lord. May I, my lord?
We have read 452 and 453 both.
Sorry.
We have read 452 and 453 both.
Yes, my lord. Yes.
450, actually 452 is the outcome of 453.
My lord, subject to correction, my lord, these are two different aspects. One is the registration fees, 452, and 453.
But there is one seal which really makes certain words ineligible. I think
We'll produce the
ineligible, I should
original.
not say, but overshadowed certain words.
Yes.
What
yes.
are those words? Adjusted with?
With the refundable amount. With the refundable amount.
Okay.
Adjusted with the refundable amount.
Okay.
Now, my lord, our point is here, you cannot dissect an admission. Kindly see, my lord, 452, if I may be allowed, my lord, just to place once more in my own way, 452, my lord. What is it saying in our, kindly see?
It says by way of a refund or a rebate of, not refund, rebate of 10% in freight for loading, and this will not continue ad infinitum because unless that is fully exhausted.
Yes. Now, my lord, here there is 2 points. My first point is you have to take the admission as a whole. This is, in my humble submission, a very settled principle of law, and you cannot dissect. You cannot say, yes, 10 crores full stop, and now I direct you to refund it immediately. And if you don't say, and for the fact that you have not paid, you will have to pay interest. So, my lord, this is the issue. Now, my lord, here there is one more submission which we are forced to make and which we have to make. But kindly see, registration fees is in respect of, my lord, Bara Jamda. Is in, my lord, DPR, Detailed Project Report of Electoral Castle at Bara Jamda, stroke sale siding at Bolani Khadan. Now, what is the registration fees, my lord? Registration fees is the fees which one's take in order to register that siding. Now, that siding, if my lord kindly comes to 228, page 228, O, this is the agreement, 228 O. Now, this agreement contains, my lord, two things. First is, kindly see, this is on 27th day of June 2011. And the land consisting of, my lord, 9.647 acres of land at Barazamda. And this is, sorry, my lord. This is, my lord, kindly take my 228O. This is the agreement of 27th day of June 2011. It speaks of, my lord, the licensor has to pay land licensing fees at the rate of 6% per annum, and land description, my lord, will find it is of 9.647 acres of land.
Is the 2008 circular on record? There are two circulars, 2008 and 2014. Where are these two circulars?
2008 circular is page 141 and 2014 is 173.
2008 is?
2008 is 141. And 2014, there are two circulars. Circular number 18 is 173.
No, this is
41
the
is
2014
one.
Which one, my lord? 141?
Yes.
Yes.
And where is that 2008?
which has been withdrawn in 2014.
Page 99, if my lord comes, page 99. This is the circular of 2008, my lord, subject to what my learned friend says, because he has given a separate page number.
I was actually the state petition page numbers were there. I'm sorry. It's become paper book. Circular 130 and 130.
Just wait. And where is that 2014? Page 141.
130, if my lord comes, my lord. Probably 141 is not there, not what is
141 is not the circular.
This is the circular of 132.
130 is the
Page
130.
withdrawn.
This is the
Circular
withdrawal.
130 and 132. The two circulars.
130.
130.
130, my lord. I am requesting my lord to come to 130.
Withdrawal is 132. 130 clarifies that it's not retrospective.
There has to be a circular number 24 of 14.
Yes, no, that is
No,
130.
that is at part 132. 132. If my lord, I am presenting the appeal, I would request my learned friend to assist.
I'm sorry, my lord. My learned friend minds that I'm
No,
giving
no,
the.
it helps, it's helpful.
I'm sorry to my learned friend, Lord. I'll not.
It's helpful, my lord. 132.
Minds that I'm giving withdrawn is one.
Yes.
Yes.
So,
Sorry.
so
So far as the registration charges is concerned, my lord, initial policy, we have calculated it, they have paid. Now thereafter, my lord, there was a policy change and we admitted that it will.
now please come to, these are all the interpretation of 2008. That is a principal policy, first
Ma'am.
policy, followed by a September 2014, where certain changes have been done, and then further followed by November 2014, where you withdrew all such policy. Now,
Ma'am.
it shows that 2008 policy indicates that there will be a there is a two decision which has been taken. One is, so far as the utilization of the railway land for a private siding is concerned, for that the different rate as a registration fees is given, and in respect of a private land, the different registration fees is given. I think their case is a private land, because 10 crores is in respect of a private land.
My lord.
Yes?
Railway.
My lord.
Railway land. Oh, sorry, 10 crores, sorry. 10 crores for the railway land and 5 crores for the private land. So that is a railway land. Now, in 2014 September, you have just modified the policy. And in September 2014, what you have said is that yes, we have re-examined the issue, and then in paragraph 2.2, you said that this registration fees would be refunded by way of a rebate of 10% in freight.
My lord.
Loading.
My lord.
That is what is there.
My lord.
Come to November 2014, where you have withdrawn.
The 2008 we have withdrawn, my lord. Why? Because it is now under the siding liberalization of siding rules. Previously it was only iron ore. Now from that siding one can transport any amount, anything and everything. If my lord kindly comes to page 4, the my lord 132 speaks of, kindly see 2. It has been decided that the policy guidelines contained in the freight marketing circular number 12 of 2008 regarding construction of private siding for loading of iron ore is hereby withdrawn. There will not be a separate policy of iron ore sidings. All sidings shall come under the purview of liberalization.
Where is this liberalization of siding rules circular?
504. 504.
Where is that?
504. Page 504.
Hey, third ache naki.
No, Malad, there are 2 volumes of it.
It ends with 549.
No, 504, 504.
This is of 2005.
Yes, it says, my lord, liberalization of siding rule circular. It was in 2005. What happened was, my lord, 2008, only iron ore. In 2014, it was decided that only iron ore is now not required. From the same siding, one can transport iron ore, one can transport anything else also. Kindly see my liberalization of siding rules, that has been specifically mentioned.
Where is the provision relating to the deposit of rupees 10 crores under 2005 circular?
No, the provisions for deposit of 10 crores under 2005, my lord, probably will not appear.
Correct. Then if the deposit is made under 2008 policy,
Yes.
which has
Yes.
been withdrawn,
Yes.
then what would be the fate of those deposits?
Yes. What will be the fate of those deposits, my lord? In this context, my lord, kindly see what the railway has to say, and that is at page 452. 452, my lord, railway is saying that this sum of rupees 10 crores will be refunded But how it will be refunded? It will be refunded through adjustment, my lord, by way of the,
That was clause 2.2 in September 2014 letter,
my lord, deeply appraised.
correct?
Yes.
Which was also superseded by a November 2014 letter.
So, my lord, and
If
this
that being the position, can 2014 circular survives? After 2008 circular is withdrawn.
sorry, my lord.
Can you pick a unilateral policy? Because I tell you in 2008 circular, there is a specific mandate which I find was that in that event, if it is not feasible, then you will have to refund 99% of the total deposits. Have you done that? Can you change the policy? Come to 2008 circular at
Yes.
page. What is the page?
99 it starts, my lord, subject to correction.
Page?
99 it starts, 99, 2008.
Yes, you come to page 102.
My lord,
It says 3.2.
yes. Yes,
What it says?
it says, my lord, in case it is not feasible to grant permission for construction of siding as per this guideline, 99% of the registration fees shall be refunded.
So,
Now, my lord, subject to again correction by my lords, this presupposes that the siding cannot be constructed. Here, the siding has been constructed. The factual basis, my lord, for refund as per 2008 policy.
so there are two. So it says that if it is not, then 99% of the total registration fees which has been paid by any person, that would be refunded. If it is not.
If it is not.
Now,
If
if this policy was modified by 2014,
my lord,
2014 September
Yes.
circular. If you come at page 130,
my lord,
2.2 says that was, sorry, we must read first the subject. The guidelines related to a freight marketing circular number 12 of 2018, which is that particular 2008 circular.
Yes.
Then it says that policy guideline for permitting the construction of a private siding for loading of the iron ore were issued by with a letter dated such and such. In this connection, the following guidelines are issued. Shall be constructed. Then 2.2 says this is where the catch is. For such investors, we have deposited the registration fees and we have given the approval before the issue of the freight marketing circular, which will be refunded by way of a rebate of 10% in freight for loading that is done after the issue of this amendment.
Yes.
So you have really carried forward this.
Deeply obliged.
So this was really an amendment of a marketing freight circular number 12 of 2018, 2008.
Deeply obliged.
Suppose if the parent circular is withdrawn,
Yes.
can a amending circular remained alive? I must.
No, if the parent circular is withdrawn, my lord, then the amendment circular will not remain alive. In that case, there is no question of refund.
Why not, sir?
Because, my lord,
Sir, you have taken a money under a policy.
Yes.
If the policy ultimately is withdrawn, will you not refund the money which you have taken under the policy?
My lord, may I just indicate
Yeah.
why?
Will it go? Because it's a unilateral decision of the railways to withdraw the policy.
No, my lord, may I?
Then the money taken under the policy has to be refunded.
My lord, may I just indicate? The policy under 2008, my lord, was that they have to pay a sum of rupees 10 crores for railway land. There was no question of any refund in 2008.
Was there any such policy prior to 2008?
Five. They are now referring now. 2005.
For such private individuals, was there any policy prior to 2008? Can you hear us?
My lord, yes.
Was
Sorry,
there
my lord.
any such policy for construction of siding by private steel manufacturers prior to 2008?
My lord, that is not on record, but I will take instructions on
No, it
this.
appears clear from 2008 circular that it was introduced having regard to the national economic requirements,
Absolutely.
having regard to the standard or volume of production being done, they were prioritized. You gave them a license or whatever you call it for constructing a siding.
Yes, for
Uh,
that, they have
7
to-
years thereafter, you abandoned the policy.
no, my lord, we have not abandoned the policy.
Continue with-
Subject to correction, my lord. There was a
2014 you have withdrawn. Then you say now it will be for multiple users, not for a dedicated person.
Yes,
Therefore, the amount which was non-refundable under the 2008 circular, you say we will refund it.
the deep leverage, my lord.
It shall be refunded henceforward by adjusting 10% in the freight.
Deeply obliged.
You did not do this for 8 years thereafter when the return
No,
corrected.
no, my lord, sorry, subject to correction.
2014 till 2022, did you comply with 452, the letter which is at page 452, which you are harping on?
Yes.
Did you comply with this in between 2014 and 22 when the writ court directed?
My lord, may I just indicate, my lord, with all humility, in order to comply with this letter, they have to, my lord, there has to be a freight of loading from that siding. There has to be a freight of loading from that siding.
Yes.
Now, how do I refund? Day one, my lord, they load.
Have you said anywhere that in between 14 and 22 there was no freight loading from that
There
side?
was only one freight loading. I have said that specifically, and I will show the documents. My lord, may I just come one after the other? The factual basis here is I am ready and willing to comply with page 130 from day one. The honorable judge said no, refund immediately with interest.
it does not say so.
My lord.
Appear to be in continuity. Hmm. This is relevant for this. What is it? Then furtherance of this, taking note of this, we have done it here. What? Existing policy. This is phase 130. That is. Yes. Here it does not require a deposit of the institution. So it should have a second.
Prior to 2008.
Yes, 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 yes. It became commercially operational also before 2008.
Yes, yes. applicability of 452 is not in dispute.
My lord, my lord,
Applicability of the document at page 452 is not in dispute.
deeply obliged, my lord.
Whether that was to be done after issuance of the letter immediately or it has been belatedly only after the court has directed, that is the only dispute.
No, no, my lord, dispute is
Say that
something
there
else.
was no occasion to do it because they were not carrying out any freight loading.
Only one, ground number 3 and 4, I have specifically said, my lord, there was only one occasion from Borajam that they have done. My lord, kindly see, our contention is after the change of policy, which 10 crores we have taken, we have to refund it. This is first. But how to refund it? I cannot pay the money from the treasury. I have to adjust it from the loading. Number 2. Number 3 is admittedly today, there was only one loading which you have done, and for your ego or somewhere else, you have not loaded a single thing from 2000.
Sir, the thing is that a person who applied for the permission, or who applied for permission to use that particular siding for the purpose of transportation of the iron ores. It was prior to 2008. It was an open siding. Anybody and everybody on a requisitions can get the number of rakes which they want. There was no question of any deposit of any registration fees. There was no question of deposit of any other amount prior to 2008.
No, subject to again correction, my lord, subject again to correction. This was a private.
Tell me, sir, any siding used by these persons, which is an open siding, not a specified siding, requires any kind of a registration amount or a fees to be paid, levied? I don't think so. It does. It is only in 2008 policy when you wanted to specify certain siding as an for the purpose of iron ore. That is an exclusive use of that siding by any person. If they want, then they have to put in certain amount as a registration fees. So you ask them that would you like to utilize the siding exclusively in that sense? Then they said, yes, I want to utilize on a railway land. You said, please pay me 10 crores of the registration fees. They paid you a 10 crores of the registration fees. Later on, you changed the policy. You went back to the original position, saying, no specific or I would say individual basis this can be used. This siding will be used as an open siding by any person who want to utilize or use those sidings, and they may have to make a requisition how many rakes are required. You will put in those rakes and they will be liable to pay the freight charges. Now, so far as those amounts which you collected on the basis of 2008, for what? To be used as an exclusive siding by them for the purpose of iron ore, to be an open one, then where is a immunity which is given? Only immunity which you say is that since you have paid me this much of amount, priority or a preference should be given if you make a requisition. Can you withhold the money? The purpose of taking the money is lost. Can you take the money?
My lord, may I just answer this in this fashion? Sorry, my lord. So far as the converting of private to public is concerned, as has fallen from my lord, that under that policy, today this is still a private siding. My lord, being today, this is my first point. Our first point is, my lord, representing Union of India. Today, this is still a private siding. Why? In order to convert from private to public, the choice is given to them whether they want to convert from private to public. But yes, my lord, I will have to show you.
No.
Where is that option?
There is no option.
That option emanates from which decision?
My lord, that option
was from November 2014 that this has been given. Show us.
No. That option, my lord, in November 2014, it has not been still today. It's a private.
Withdrawn. You say that in paragraph 2.0,
Yes.
It has been decided that the policy guidelines contained in Freight Marketing Circular number 12 of 2008 regarding construction of a private siding for loading of the iron ore is hereby withdrawn.
Yes, the construction has
not-
already,
There will not be a separate policy for an iron ore siding. All siding, yes, all sidings will come under the purview of liberalization of the siding rules circular.
this
In
came
this
in,
connection, for resolving the proposal which are at the different stage, the complete guidelines have been issued on 29/9 Freight Marketing Circular number. This issue will be a concurrence of this. So you have really converted it.
my lord, may I
No
just,
private siding for iron ore.
no private siding for iron ore, but private
What they
siding,
wanted for iron ore, sir, they are either doing a captive mining or I believe so. What is captive mining or open
no.
mining? I do not know what
No, my
you are
lord,
doing.
today, subject to correction by my lords, today they are the sole charge of that siding. Today, nobody else can, whether they do iron ore or not iron ore or something timber, it is for them to decide. Now, subject to correction by my lord, nobody else can decide because it is under their exclusive possession. Sorry.
Rules of policy shall apply. What is the rules of policy? The policy has gone. There is a writ petition. Acquisition, my lord.
Writ petition.
Where is the writ petition?
Starts at page 1 to 74.
Show us the reliefs claimed in the writ petition at what page? Or page 69.
69. Lord.
September 23, 2014, 15 order. And refund of this declaration that clarified as clarified by such and such. It's not applicable to a private sector. There is another issue. CA is another issue. Fixation of the price of the land and all everything. What you have done? That's the reliefs claimed in clause B.
They wanted cancellation of those two circulars.
I tell Lordship Lord, our stand was that freight marketing circular number 12 itself has no application at all. Because in our case.
But you have acted upon it.
No, we
on
have
the
not
bit-
acted upon it.
You deposited 10 lakhs,
Lord.
10 crores under
Lord,
what?
we were.
Under what circular you deposited 10 crores?
I tell you, Lordship Lord, from the documents of the railways, it will appear that everything in connection with circular was done in connection with the siding was done in terms of the 2005 Lord the policy.
Was there any mandate in 2005 that
Nothing.
10 crore?
No.
Then why you deposited?
The railways compelled us to deposit 10 crores, saying that we
Whatever,
will not.
and you were just sitting tight over the matter.
No, under protest we gave it, and we filed this writ petition saying it's not applicable.
So when you file the writ petition,
When did you deposit it?
Because
Why?
we were not giving. We were not.
When
getting
did
the-
you make the deposit of 10 crores?
When?
When?
Lord, in 2011, Lord. I tell you, Lordship, we were compelled to make the deposit because they were not giving permission for commissioning.
But you have filed the writ in 2016.
Lord,
How are you saying that was?
It is because thereafter, Lord, we took the stand we took was freight marketing circular is not applicable at all. We are not.
no,
required
that
to
is
make
what
any deposit at all.
not the relief which you have claimed in the writ petition.
Yes, Lord, that is also.
Please look at, so far as the first A is concerned, you have said that to rescind and set aside September 23, 2015 circular, impugned letter, and then refund of 10 crores
Yes, Lord.
with interest.
Yes.
B, declaration that as clarified by 2014, that
Yes.
is, I
12
believe
is not
September,
applicable. 12 is not
September,
applicable.
and then the November,
We are
the
saying as
the
clarified by 18
the
and
the
24, FY 12
2008
is not
circular was not applicable to the private siding of
Yes,
the
Lord.
private,
But
the
as
petitioner number
clarified.
1.
As clarified, is it
That-
severable?
Yes.
This 2008 and 2014 all are interlinked.
Lord,
They are not severable. It
But
doesn't
2000
appear to
like
be
a Lordship,
severable.
2008 circular said that only prospective sidings which are yet to be sanctioned, which are yet, no work has not yet been done, for them 10 crore will be applicable. The railways compelled us to pay 10 crore on the ground that we will not give you commissioning certificate. So we were compelled to put the money under protest. Thereafter, Lord, when the circular of 2014 came in, the railway itself
Your
clarified.
stand is that because you were not an applicant under the 2008 circular, that you were not required.
Exactly. Then when the 2014 circular came out, 2014 circular clarified that the earlier circular of 2008 only applies prospectively, not retrospectively. Therefore, if you have taken money from anybody, refund it.
And
So,
what about CA?
look, this is with regard to the land licensing fees, for which we have a claim of 9.5 crore, which they took from us, and in their letter they admitted they made a mistake in the calculation. That is that next letter which your lordships had seen, the two letters. They admitted they made a mistake in their calculation. And they computed the refund and they gave us the letter saying this is the amount refundable, except that they are asking for keeping it for another 5 years.
Not 5 years. They say that 10% rebate in the freight charges.
No,
That is the registration.
that is for
Restriction.
regard to land.
This is the land licensing.
Land
They have
licensing charges.
admitted.
They said the amount is wrongly calculated. The recalculation shows you are entitled to refund, but we are keeping the money back for your future license fees. So they say for future, we are going to keep the money back. Now they have given a calculation saying up to 2030, we are going to keep the money back. We are keeping it in advance with us for you to make payment up to 2030. The amounts are admitted. But they're saying we hold it back till 2030.
My lord, may I come back tomorrow, my lord?
No, continue and finish it off.
But I have got some problem. If it is comments to my lord, it's a personal request. If we can come back tomorrow, or else, my lord, whatever my.
Then not keep it the first matter or second matter, but
Yes, yes.
somewhere high up so that it's taken up.
Absolutely.
She is in personal difficulty, my lord, there's nothing to
No,
be
no,
said.
personal, no, it's a profession.
Tomorrow, as for orders,
My lord,
10:30.
my lord, deeply obliged.
বলবে তো Well, we have the lead to mention, my lord, there was one matter, assigned matter. That, my lord, Mr. Mukherjee is appearing for the petition and the,
Yes, in the morning it was called, he was not here.
my lord,
So these are
Can it
not
be ta-
assigned matter. These are the point of reference has to be answered.
my lord, husband, can it be taken up on 2nd of May at 2 p.m.?
You finish it off. It cannot be,
No, my lord, on 2nd of May at 2 p.m. it will be finished.
do it on 2nd of May, 2 p.m.
And my lord, I was having another.
For the corporation.
দাঁড়াবি তো তুই।
Corporation is present, Lordship, they have no objection if it is.
Yes, yes,
but,
second.
My lord,
second
ana-
2 p.m. Lordship.
Yes, write it. Hey, list করে দাও। List
my lord,
করে দাও।
can I make one humble prayer? My lord, that another criminal appeal which is fixed tomorrow, can it be taken up at tomorrow 2 p.m.?
What?
My lord. But tomorrow, my lord, 2 p.m. till 4:30 will.
Friday will be a lot of broken benches and all, everything.
No, my lord, tomorrow, Thursday. Tomorrow it is fixed in the morning. I was
Correct.
only praying, can it be taken up at 2 p.m., my lord?
2 p.m.
2
Oh,
p.m.
you say the day after tomorrow, that's why we
No, my lord. Tomorrow at 2 p.m.
come at 2 p.m.
What are the?
Inform the other side of,
I'll inform the other side.
yes.
Good.
2 p.m.
Lord, the defendant, Lord, is the appellant before your lordship. Lord, in a suit for specific performance of an agreement for sale. Lord, the appeal is directed against me, Lord,
Other side,
the other side, Mr. Oyon Banerjee had appeared. He has used, my lord, affidavit in opposition to my stay application also. And, my lord, I have a application under Order 41, Rule 27. So that has to be heard along with the appeal. So
they
otherwise,
have to give an opportunity to deal with that.
Lord, they did not choose to file any affidavit to that.
There was no direction also passed.
Lord, subject to correction, Lord, there was a direction for exchange of affidavits, Lord.
So they have done it.
They have done in case of the stay application, but not with respect to Order 41.
That is
Rule
what
27.
we wanted, that should be given an opportunity.
So the difficulty, my lord, what I am facing,
Difficulty
let
is
there be a
created
status
by you.
quo be maintained.
Difficulty is created by you. Why you filed Order 41, Rule 27?
But certain documents are absolutely
then that is
necessary, my
when
lord,
they must
for
get
your
an
lordship's kind
opportunity.
consideration. The fact of the case is, my lord, they are pressing
It
on.
appears, Lakho. The appellant has filed an application under Order 41.
And Lord, perhaps we have also filed a reply, Lord, to the opposition.
Yes, we have seen the replies with us. What is the matter about?
So the case of the plaintiff is, Lord, that led by Mr. Owen Banerjee, my Lord, kindly allow me short password.
Call him.
Lord, 4 kathas, 8. Lord, 4 kathas, 8 chitaks land, Lord, in VIP Road. In Lord VIP Road, Holdiram area. Lord, along with building. Lord, the plaint case is that the total sale consideration was 3 crores. We agreed. We means, Lord, one of the co-sharer as per, Lord, their stand. Uma Shankar. Lord, he agreed to sell the property. Lord, he accepted 25.5 lakhs. And thereafter, on the date of registration, he did not turn up. That's why, Lord, this suit. In the meantime, in furtherance of that agreement for sale, possession has been handed over. That is the plain case. Based on that, ad interim injunction was secured, grant. We filed, my lord, a written statement along with the counterclaim that no such agreement was signed. The entire deal was with respect to granting some of the portion on lease, 51 lakhs as security deposit and 8.5 lakhs per month to be the rent. Lord, one fine morning, they barge in the property. We have documents to show, my lord, that these vandalism has taken place.
Yes.
Lord, they have barged in the property. We have initiated criminal proceedings. Lord, we have filed a written statement asking for recovery of possession, and my lord, suit is also filed for recovery of possession. So, my lord, this is the status of the situation. In such a situation, my lord, the trial court proceeds to grant that I will not transfer the property to any third party. The first now what has happened is this trespasser is, my lord, inducting regular tenants in the property, earning from the property, from my property, and fighting litigation against me. This trespasser is inducting tenants in the property, earning from my property, and fighting litigation against me.
Not your property.
But this is my property.
The agreement for sale does not create a property. Oh, you are the owner.
Yes. That is the problem. I have been.
You did not file any application for injunction.
Lord, application for injunction, but I
You are
contested.
exceeding an order of injunction.
I contested.
Whatever.
At the best, a status.
You can't say that they are continuing
to balance the equity. Lord,
what balance the equity, then the court will pass an injunction against them also.
What I am suggesting, Lord, is to
Under what
to balance the equity.
provisions?
Lord,
Tell us.
to balance the equity, the court has granted injunction against me from not to transfer.
That is a different issue, whether any injunction can be passed against you. But you are raising a issue which is absolutely foreign to the litigation.
Lord, but that is a fact that I have not filed an injunction application.
So you ought to have.
Yes.
But you have chosen not to. You are simply contesting that no injunction can be granted.
No, but kindly seize the predicament of this entire situation, precarious situation.
Whatever, then you'll have to take. There is no fetter in the law that the defendant cannot seek an injunction in a plaintiff.
And when I have a counterclaim on it. And when I have a counterclaim.
Even if you do not have, even
then also I can take off.
You can.
Then also I can take off. Lord, kindly seize the basic things. Few documents I'll indicate. Lord, kindly takes my order 41 rule 27. So this injunction cannot stand for a day. Kindly seize, my lord. I'll show from the records. The person who has verified as director. Lord, kindly, may I take your lordship, Lord, to page 27. I'm sorry. Of my stay application.
What for?
Page 27 of my stay application.
What for?
The person who is affirming the affidavit, claiming to be the Lord director of Lord the company, is not even a director on that particular day.
Subsequently, he may be an authorized person.
Lord, he claims that director and authorized signatory. Lord, he's claiming himself to be a director.
By the board of directors.
He's claiming to be himself to be a director on the date of affirmation.
Sir. Section, I think the form 13,
32.
13B, I think, or 13.2 Form
32,
13.
my lord.
They may not have filed before the registrar of companies.
My lord, he was a director before filing the suit. He resigned, the suit was filed, thereafter he joined.
Whether the registration, the resignation was uploaded, accepted.
Yes, that's the
accepted
document.
in
Yes,
the-
my lord,
in
that
the
is the document I'll show.
Ministry of Corporate Affairs. When
Yes,
they,
my lord, that is the
company-
document I want to show to your lordship.
So he may be an authorized person.
But the director's claim is there.
So one claim fails,
No,
but
that is
the
one
law
score.
permits that either director or any person authorized.
So that is one score of that.
That's another thing.
So that is one score of the, my lord, the matter. The other thing is, my lord, kindly comes to, my lord, the plain case once. There is no resolution, my lord, otherwise also submitted in the court below. My lord, showing, demonstrating that they are, my lord,
It's a
authorized.
curable defect.
Lord, what I was
It's
on,
not an incurable defect.
when a person is coming to ask for injunction, the prima facie conduct, I'm only on that. Kindly seize the conduct. And thereafter, my lord, with the plaint case made out and this kind of injunction, now my property is being commercially utilized. It has been, a part has been converted to a
This cannot
restaurant.
go into this. Only question is whether that can be injunction can be granted or cannot be granted. That's all. What was the nature of the injunction which is made absolute?
My lord, it is restraining me from creating third party interests. Restraining me from creating third party interests.
Not to sell.
Unregistered, my lord, sale deed, although, my lord, after NN Global, my lord, in injunction stage, does not bear much. The other aspect of the matter, my lord, is with respect to, he claims that I am the sole owner of the property, although there are other co-sharers of the property. Now, when I declare that in my written statement, they come up with, my lord, an order 1 rule 10 application. So again,
Subsequently.
but one more contradicted thing in the plaint. Kindly comes to the plaint once, page, Lord, 12 of my application.
Why you put your signature in the agreement showing yourself to be the absolute owner?
But I did not. What my case is that, my lord, agreement was there with respect to demising the property on lease. That is my case. 51 lakhs security deposit, 8.5 lakhs monthly. That was the understanding. And that was entered with one Raja Shaha, not with the present, my lord, plaintiff.
What is the agreement? Who is the purchaser, intending purchaser in the agreement?
Purchaser is, my lord, a company, Macadam Leisure Private Limited.
So they are
That's
the
the
plaintiff.
plaintiff. He's the
They are the plaintiff. So
they are the plaintiff.
why you put your signature?
The signatures were obtained.
Obtained.
That is being challenged in criminal proceedings. No, those are part of Order 41 Rule 27. Those are all part of. But that's why I'm beseeching your lordship, not kindly takes the plain case once. They have said that they have paid me 25.5 lakhs on account on different dates.
Many things are being said from you.
No,
Have you
in the
read
plain
the
case,
Have you read the order?
my lord?
Have you read the order? What you gather from the said order? Tell me.
The main consideration of the order is that money has been transferred. The second aspect,
Where do I get it?
Lord, kindly comes to the first page, middle portion, Lord.
Yes.
Thereafter, in the year 2009, the
What it
paragraph
has been said, it is,
transfers, Lord, of
what
the
is
total
this?
consideration.
Is it
That's the
a-
factual
is it-
case of the plain.
This is the contention in the plan.
Plain.
Then?
That 25.5 lakhs were transferred
Then,
and consideration amount was 3 crores in
Then?
total.
then,
Thereafter, Lord, written objection was there.
yes.
Discusses considering that all aspects, there is some tribal issues, whether an agreement for sale was made between the parties or not, or the plaintiff advance any consideration money to the defendant on basis of the said agreement for sale, that by objection the defendant clearly denied about the alleged agreement for sale. So such issues will be decided by taking evidence from both sides. However, there is a prima facie case and balance of convenience in favor of plaintiff. Lord, how the court arrives at this finding, there is no reason, Lord, provided for that. Under such situation, if the ad interim order of injunction which was passed in such and
So
such,
what is your stand?
Lord, my stand on injunction, Lord, a
No,
frivolous,
no, after looking at the judgment.
my stand is, Lord, I am before your lordship. I have assailed that before your lordship, Lord.
Simply
is my stand.
standing without making a point will do.
So that is what I am trying to demonstrate before your lordship, Lord. There is a contradiction from the plaint case itself. The prima facie case the court has arrived at, Lord, does not come, Lord, it doesn't even, Lord, take a bath. There is no prima facie case from the disputed documents of the plaint itself, far less, Lord, balance of convenience or other factors.
I would only say, my lord, where is the finding or reasons assigned? Is this a proper reason for making out a prima facie case? What is the role? Is it a reasoned order?
Not admitted fact is that of.
I am asking you, is it a reasoned order? The first page contains the entire reproduction of the plaint.
Fine.
The second page, the first paragraph contained the written objection. And the second paragraph, is it reasons which has been recorded under Order 39, Rule 1 and 2?
Third paragraph is the not reasoning.
That is the only reasons.
Travel issues are there.
Then only thing.
The facts
So-
have been recorded. And the
I am just asking, after Shiv Kumar Chadda, facts are recorded, everything, and then quoting the law, Order 39, Rule 1 and 2, and then granting an injunction. Is this a proper way of exercising the jurisdiction?
now, in a proper case,
Shiv Kumar Chadda, the Supreme Court has deprecated it.
reason is not heart and soul of an order, I know, my lord. But
No.
in a proper case, your lordship's court cannot supplant the reason.
No, no,
If it is a fit
no.
case. I only wanted to show, my
No.
lord, that in this case,
In Suprati Ghosh, it says nullity. Has gone further. Order is a nullity.
no, I would say that it's not absolutely devoid of reasons, but my lord,
This is what is the reason. Where is the reason? He says that whether it has been paid, it has not been paid, tribal issue. Is this the reason? Where is the prima facie case? That it appears from the documents that there has been an agreement between the parties, the payment of the earnest money, a part of the constitution money, the
And
further action of giving
Position
a position,
position handed.
everything has to come. Where is that finding?
Court has not, on the basis of the facts recorded, my lord, court has proceeded to say that there were tribal issues.
And then when it says the position given, it's not a question of protection of the position. Interim order was not to protect your position. Interim order was not to alienate.
Not to alienate.
That's
Not to
all.
create third party, because they are also in
Position is
possession
not
of
in
a
position is not disturbed. You have
They are
not
also
sought.
in a possession of a portion of the property. One floor is occupied by them. The rest of the building has been handed over to us.
Whatever, we are not
Which they have
concerned
not
with
come
that.
into play.
But there must be a
handed over.
proper recording of the finding. That has not been done.
And not they take up the issue now that there's forgery in the deed. That is also, it becomes another triable issue. As per their additional evidence.
That is
they
a,
have filed
that is a
suit.
different issue. That is a different issue. But the question is, would be that the money was taken. There must be a receipt which is given. There must be some letters which have been exchanged between the parties showing the conduct or the nature of the transactions.
They have shown
All
the
this, all these
conduct.
things have to come. You have said that there was a date for execution of the sale deed. You did not. However, he subsequently put his signature in the agreement.
Draft agreement was handed over, that was returned.
True, after that,
stated
he's put
to
his
show readiness
signature.
of
Now
bidding.
he says that I have not put my signature. These are the issues will be decided.
Now disputing the
But,
signature.
but there must be some finding recorded by the court. Nothing has come.
So far as payment is concerned, payment and handing over possession from the pleadings and the recordings thereof.
Where is the
not-
finding?
I would humbly submit that page 1, after the first one, third paragraph is the case made out. Then
These are all case made out. If you go through the plaint, you will find everything is reflected from there. This is really a reproduction of the plaint.
of the plaint case.
And then he says by written objection what they have said.
By filing W, they have made out this case. So it is not a case set out, but the defense set out. Basically, court has not set out. This is the defense.
So this is
taken
a
by
plaint
the-
set out. This is the defense set out, and then the consideration. The reasons. Nothing. It has to go
During all
back.
aspects, there is some tribal issues, whether an agreement for sale was made between the parties or not, or the plaintiff advanced any consideration. So, this is not, these are the issues court has come to. Talked about the tribal issues. Kindly see, it's a very short observation, but said that these are the tribal issues and these are to be decided through trial. If your lordship says that is not the thing that has gone after the recording of facts. The issues have been set out. What should be the tribal issues? But the specific recording regarding my readiness and willingness, all
Mere
there
the
is a
issues
pleading.
are tribal that constitute a prima facie case, I am asking. There must be a positive finding by the court saying that these are the certain rights have been created, something has been done on the basis thereof. And this is what I find that they are they're trying to sell the property to a third party. Everything, these findings should come in support of that. Nothing has been recorded.
Court has not separate. Court has recorded, but not separately as the court's finding.
No,
That
no,
is
no.
what
It's an independent. These are all the reproduction of the plaint case, sir.
Lordship, kindly see, peruse the petition and the objection. So after perusal, these are the findings. We cannot.
Where is the peruse the petition and objection? Where?
Kindly come to the first page, my lord.
Yes.
Record is taken up for passing order. Peruse the petition and its objection.
Correct.
Then the case, the
So
finding.
what is then the main
Then
contention of the
contention
petitioner
petition
is
that. So it is not
this is
some
what is
reproduction.
recorded. Then by written objection, he says this.
Facts have been stated, not as a plain case, but the finding of the court is only that there are tribal issues. Court has not recorded, my lord, that prima facie because of this. I find there is that part is only missing, my lord. These are not recording of fact. I cannot say replica of the plaint or written statement. Court has recorded the facts, but only that finding that there is a prima facie case is missing. Only says there are tribal issues
Yes.
instead of saying, my lord, that tribal prima facie case is there. If your lordship takes it in that manner, my lord, court has discussed everything, what the parties have said. But instead of saying that there is good prima facie case, court has merely said, considering all aspects, there is some tribal issues, whether an agreement for sale was made between the parties or not, or the plaintiff advanced any consideration money to the defendant on the basis of the said agreement. So this part, my lord, is not the only infraction. Instead of saying that I find prima facie case, this has been said. But the facts have been, my lord, narrated entirely.
Yes.
Yes, a draft agreement was also handed over. As per the plain case note, you have stated that. So the part of readiness and willingness, there is no lacking on the part of the plaintiff.
My lord, are Anup, Jyoti, Sakshi, Palak, and my lord, they have filed an application for.
Anup is dead.
No, Lord, Anup's wife, widow, Jyoti, Sakshi, Palak, and Jatin.
Anup was married.
Anup was married.
That was suppressed to us. That is not.
Everything was suppressed because nobody signed on the document. We have filed an application for handwriting expert, Lord, for and getting the safe custody of the document. That is pending since 2021. This order comes in. He knows nothing of the property and came to buy for 3 crores. Gives me
And you were so innocent that you received that 20.5 lakhs of
25.5 lakhs I have received only on account of granting on lease.
Can you grant a lease in
Not as
absence of your other the heirs of the Anup?
Lord,
How you
Anup,
will grant?
no, Anup is my son.
I know, sir.
So, Lord, I am the property.
Sir, I have seen that particular recital in the deed.
Very. Lord, if
He
that
has
is,
said that Anup being your son died unmarried.
it's a
So you
family.
are the only surviving
It's a
heir as a father.
It's a family property. Basically, I
What
say
family property? It was purchased by your wife
yes,
and 2 sons.
my lord,
One son died
my lord,
while he was unmarried.
my lord,
So it divorced upon the mother.
my lord.
No problem.
No problem.
Mother means your wife died.
In
Then
2008,
it divorced upon the Anup and you.
my lord,
Then he says Anup also unmarried died. So you are the only person who succeeded. So what family property?
no, that is not the case.
But now it appears Anup was married actually. That's the only. And
Fine.
Anup's have a wife and those
Widow
are your
and 3
daughter-in-law and your grandchildren.
But
That's
two-
all.
Absolutely.
So
It's a family property.
it's a family
They're
property.
all within family. My family. Lord, I can grant my property on lease.
You
Lord, being one of the co-sharer,
in exclusion of your daughter-in-law and the
as a one of
grandchildren.
the co-sharer, I can always grant the property on lease. Lord,
Okay.
your lordship knows much better than me, Lord. For leasing out the property, there is no difficulty.
But it does not appear from the agreement that it was for leasing. And for leasing, how you
That is a
receive?
forged document.
I'm saying for leasing, how can you take the money in part?
Lord, the
How?
agreement was
Under
51
what? Is
out
it a premium?
yes.
Is it?
Security deposit, 51 lakhs for security deposit. Out of that
And
51
in part?
lakhs. In part.
And in you have given a position.
The possession was taken away by them. Police complaints are pending. Lord, criminal proceedings are pending for criminal trespass and Lord, thereafter encroachment. I have a
You
file
did not immediately come forward and file a suit for.
recovery of possession is also pending.
That is a counterclaim you have made in their suit.
No,
I am
that's
talking
a
about a
separate
suit.
That's a separate suit. That's a separate suit that is also pending. Lord, that is page 59 of my order 41 rule 27. Page 59. The plaintiff have annexed. The plaintiff have annexed for recovery of possession.
Yes.
They have barged in the property, now converted in, Lord, got by way of this injunction order, they have got Lord, electric connection, they have got water connection. Now they are running Lord, a restaurant in a portion, and they have given a Lord, some bicycle shop Lord, to the other portion. Utilizing the property in commercially and litigating, earning from there, litigating against me. This is not the current scenario. And Lord, my application for handwriting expert and Lord, for safe custody of this document agreement for sale, alleged agreement for sale, is pending since 2021. That is kept pending, and this order comes in with these reasons. Kindly see, Lord, 6th of January 2021, immediately after filing of the suit. কবে suit file হয়েছে? 20 সালে কবে file হয়েছে? The suit was filed in October 2020. January 2021, I make the application Lord, for handwriting expert. Till date, it has not been decided. Kindly seize Lord, the certified copy once. একটা copy আছে? একটু জজ সাহেবকে দাও। আরেকটা copy আছে? Lord, kindly excuse me, Lord. আছে? ছয় এক এর হবে। এর আগে হবে তো 6 দিন। হ্যাঁ, Lord, এই যা। No, here are 2 copies, my Lord. Lord, 6th of January 2021 order, kindly seize, my Lord. Before disposing of Lord, the injunction application, the court should have Lord, disposed of my handwriting expert application first, because that's my positive stand. And on the very first available opportunity, I filed that application. That those are not my signatures.
What was the objection which we filed in the trial court?
Trial court. No objection. Page 59, my lord. Page 59 of the stay application.
Lord, paragraph 6, your lordship would find, Lord.
What? You claim to have paid money by cash?
That is not
Company,
a portion, not the entire sum, my lord.
Sir,
The major portion has been.
can a company pay 10 lakhs rupees cash under the Income Tax Act? Can you?
156 plus 3.
And that is not one, several 10 lakhs. I find from page 103. Can you? Yes.
Oh, I'm grateful, Lordship.
This is from your petition under section 156 clause
Yes,
3.
I'm grateful. Completely different case has been made out there.
But these payments, my lord, if I cannot prove check payments, so far as the check payment part is concerned, that my lord, the court has come to the finding.
Show us the document that how they have treated this payment from your application for injunction. Show us. Let us find out.
Page 28, my lord, of my stay application is the injunction. Can, lord, 1. No, can 2.
Stay application.
Can 1.
Can one.
Can 1. Stay application. Page 28.
20?
28. 28.
No, these are all the petitions. I just wanted how that, what are the documents? I just wanted to know. You have not annexed the document.
I have annexed the bank statement of the plaintiff's company, Annexure C, page 34. Annexure C is the bank statement.
Where I just wanted to know that how and in what manner this has been done. There must be some kind of a correspondences.
The suit proceeds on the basis of that 25.5 lakhs. And that this criminal complaint goes for 1 crore. After filing of the suit, completely afterthought. And here, my lord, the concept of these cash transactions come in.
Show us the document.
This is the injunction application, my lord. Annexure C is, my lord, the.
Show us your application.
These are the, my lord, transactions.
Okay,
Injunction application.
এই তিনটে payment তো? Those are the 3, not that 25.5 lakhs. Those are the transactions.
There must be something.
And out of not that 25.5 lakhs, not 2 lakhs was paid by that Raja Shaha, not by the company also.
Let's consider that. He may be whatever.
Yes, that is, I'm not getting
maybe.
it.
He is one of the directors of the company.
The stand itself is manufactured.
Account থেকে withdraw করে দাও।
তো ভেঙে ঢুকেছে আবার ডেলিভারি না কে হ্যান্ড ভেঙে ঢুকেছে দখল করে দিচ্ছে
তেইশ পঞ্চাশ
Sir, you are not a trustworthy person. In your objection, even you have gone to deny all these payments which have been made to you. Can you be relied upon?
Lord,
You
I,
have not said anything about all those payments. Everything you have denied that you did not receive a
Lord,
single
in the
money.
written statement, I have specifically
No,
stated
sir,
that I
in
have
the
received.
written objection,
Lord,
in
my
the written
specific-
statement with counterclaim,
my-
we have seen that.
My specific stand is I have received the payment.
No, I have seen, I am reading it. I was just trying to find out. Come,
And not.
I am giving you. Come to page 45, paragraph 11. Come. Line about 1, 2, 3, 4, 5, 6, 7, 8, 9 from the bottom. It is also denied and disputed that on 5/11, at the request of the defendant, paid a further sum of rupees 13 lakhs as alleged at all.
Lord,
Then it is,
Lord, I'll just
you
indicate.
have denied 13 lakhs 50,000 to have been paid to you.
Lord, I'll just indicate one.
Then you have further denied, I can understand, page 46. Just last sentence of the paragraph 11. Line about 1, 2, 3, 4. Above paragraph 12. The answering defendant states that he never visited the office of the plaintiff and a sum of rupees were never paid by the plaintiff company.
Lord, one with respect to your lordship is at page
So 2 lakhs, you said, I can understand that 2 lakhs. Then you have admitted who is this. Come to page 44 earlier. Above paragraph 10.
My lord.
4 line. The answering defendant said he never have an efforts to sell the property either to plaintiff or anyone. However, the chairman of the plaintiff company, Raja, approached for this. So you admit he's a chairman. Then payment, you said that company has not paid. 2 lakhs rupees appears to have been paid by Raja, who is the chairman of the plaintiff company. And then everything you have done, you said only for the purpose of lease. Then question is that what for the payment was made? And you have denied that you did not receive any money.
Lord,
And your bank statement shows that you have received those money.
yes, Lord, it's my specific.
No case. Where is a specific case, sir? I'm reading. Please tell me from written statement
I'll
you
just
have
read.
admitted.
আরে একটা জায়গায় রয়েছে case. Lord, kindly comes to page 51.
Page
51.
51,
My lord.
please. So it is a counterclaim.
So
I'm talking about,
also my
sir,
stand.
sir,
That is
this
also
is
my
what.
stand. Lord, written statement and counterclaim has to
No,
be read
it is
as a
not.
whole,
It is
Lord.
separate because come to page 50. Separately filed.
Lord, but it was there.
Not along with the
Lord,
written
it was
statement.
there on record when the injunction was being heard.
Sir, then that's why I'm saying, if a person has prevaricated his stand, at one go he say, I never received, I deny. And at one go he says that I received. whether he is a trustworthy litigant.
Lord, if I'm saying,
His statements are to be taken as correct.
if I'm saying that I have received that amount, if I'm saying that I've received that amount, the Lord, documents show that I've received that amount. Lord, there is no dispute with respect to the receipt of
Then
23.5 lakhs.
the question is again, sir. The question is the belief and disbelief. If this is the litigant who at one point of time saying that I have not received, I dispute, and who is saying that at one point of time in the latter period he says that I have received. Whether such a litigant should be relied upon that this payment was in respect of a granting a lease and not for sale. Can it be relied? Can he be relied upon? He's a trustworthy person.
Well, if that is the case,
Then-
then my
Then what
Sir,
is the
what did
prima
I do?
facie case?
what did I do, my lord, after I got the notice of the plaint? I immediately lodged an FIR.
Sir, I have
complaining
seen
of the forgery.
on 1st of November or December, you allege that they trespass. On 8th of November or December, you went 7 days delay. A person has ransacked your property, somebody has entered. Will you not immediately go to the police station and lodge a complaint? 7 days delay.
Lordship knows, my lord, how the police functions, my lord.
Sorry,
I had,
no,
my lord,
no, it never said anywhere that you immediately went. They did not lodge any complaint. You would send it by money order, whatever, you did not.
whatever the situations might be, my lord, the situation is, my lord, that today a third party is inside my property, exploiting my property, and asking for injunction based on documents which does not is not substantiated.
Yes, you have paid me, but for lease. Then question is whether it is for lease or it is not for lease. I will decide it. It will be paid.
Kindly comes to page 57 and 58. It is not two documents. Well, only the cost title has been separately included.
Sir,
It is a single document.
You can't transfer the
written
property.
statement and counters.
You can't transfer the property to a third party.
Lord, I am being injuncted in a suit, Lord, where the claims are unsubstantiated.
We will say so.
Lord, and that is for free. In a
We'll
suit
say
for
so.
specific performance,
Say
for
so.
3 crores, admittedly 3 crores is the money.
Correct.
For free, he is enjoying the blood.
We'll say so.
Lord, kindly considers this, Lord. I have taken the stand. What did I do? Lord, I have come to court immediately after, Lord, knowing I have filed an application for
Yeah.
forgery. That application stands pending as on date. In 2021, January, I filed, Lord, for forgery.
Come. Yes.
I appear for the appellant, my lord. May it please your lordship, my lord.
Pursuant to your lordship's order, my lord. I am filing the report, my lord.
My lord, no copy has been served to me, my lord. May I file my exception to the report, my lord?
Everything has been complied with, my lord. The vehicle is running to and fro, my lord. Pursuant to the permit given, my lord.
Is it a assigned matter to us? Is it a assigned matter
No,
to
no,
us?
not assigned. Group 7 matter, my lord.
Group 7. Okay.
Yes, sir.
Yes. What is the report? What report says?
The report says, my lord, the person who was obstructing, my lord, being the member of the RTI, my lord, being a member of that
Yes.
not before, my lord. He had been arrested, my lord.
He has been arrested.
Yeah, he had been arrested and thereafter released on bail, my lord.
Oh.
Thereafter, secondly, after your lordship's order, he has made an inspection over there and thereafter he has.
And then?
And thereafter, my lord, now following an order dated 28/3, page 2, my lord.
Objection.
Following an order dated 28/3, the Honorable High Court Calcutta in matter, a district inquiry was conducted, and during thorough inquiry, the copy of the regulations regarding the issuance of NOC for the application having memo number such and such dated 22/3/24 has been collected from the Transport Authority Motor Vehicle Section, Krishnanagar, Nadia, which confirmed the ownership of vehicle such and such by Sharan Kaur and Jaswinder Singh, respectively, and both buses are plying from Krishnanagar to Asansol and Krishnanagar to Burnpur via Navadip bus stand. Xerox a copy of the said NOC is annexed here with my lord. And thereafter, subsequently discussions between the ART of Krishnanagar, the opposing party and the petitioner on 13th April 24, facilitated by the police intervention, resolved the allegation, allowing both buses to resume their prescribed routes without incident. In this regard, a written declaration was submitted by Jaswinder Singh, son of Modi Karan. Everything is
My lord, the extortion is there, my lord.
separate to his.
Yes, my lord. My lord, there were many injuries, very many injuries, my lord. Yes, everything, my lord, we submitted report, everything we submitted, my lord. My lord, let me file an exception to the report, my lord. My lord, 326 was there, my lord. And my lord, the charge of extortion was very much there, my lord. Because he was demanding money, my lord. He was demanding money to let the bus fly, my lord. And your lordship asked them to file a report in respect of the Badli workers they are employing, my lord. The person is exercising statutory and colorable power, my lord. He is employing persons on his own. He is putting his Badli workers on our buses, my lord.
Another application,
And demanding money from us.
Persons, my lord.
He is very powerful, my lord, in that area.
Action is different, my lord. Here is the cause of action that is he has been prevented from plying the vehicle for these persons.
He is a law unto him.
While criminal cases against him.
My lord, the bus was not plying. My lord. My lord, I haven't got a copy of the report, my lord. I have to deal with it. Yes, my lord. My client has given me specific instruction that he was put under indirect pressure to sign this letter. My lord, my client told me yes, my lord. My lord, I advised him to file a general diary or to inform the superiors, my lord. Because, my lord, he was detained inside the police station and this declaration was taken from him. He was made to sign this declaration, my lord. And the bus was stopped. Even after your lordship passed the order, my lord, the bus was stopped by the association, my lord. Bus was not plying and this declaration was taken, my lord. On this date also, my lord, the bus was not plying. My lord. And my lord, kindly see the last order your lordship passed, my lord, regarding the employment. Yes, my lord. Yes, my lord. Yes. Yes. My lord. That was much before. My lord. Your lordship, my lord, asked them to file a report about the Budley workers they're employing in our buses, my lord. Yes. But my lord, they are employing the workers in the staff in the bus, my lord. That very person, my lord, the private respondent, he is exercising colorable power. My lord, I want to put it on affidavit. Let me file it. Yes, my lord. Let me file an exception to this report. I will bring everything on record, my lord. And the charge of extortion has not been, my lord, included.
The defendant number 1 and 2 is the appellant before your lordship, challenging the order of injunction lost in a partition suit.
I beg to appear for the respondent number 1 to 11 plaintiffs, led by Mr. Bhattacharya.
If your lordship will turn to the plaint itself, that your lordship find the application for stay, page 19. I've got it. দুটো দলিল According to the plaintiff, the Karim box was the sole owner of the property. He transferred the property in favor of the defendant number 1 and predecessor of the defendant number 1 and 2, and the predecessor 3 to 8, 3 to 9. On basis of and the rest portion, they are in usually position. These are the sum and substance of the plaint case. Now, my lord, can you turn to my written objection to the said application? Our case is that the Karimbox during his lifetime transferred the property by way of demarcation to our predecessor. That also corroborating, my lord, I am drawing your attention for the objection portion, that your lordship find status quo. Construction. Yes. Construction is completed, only some portion is required to be done. That commission report is there, my lord. I'm on this, whether this suit on the basis of which this injunction was passed can be permissible. It is added. If it appears, my lord, I'm in demarcated position, the predecessor transfer the property by demarcation. Whether, my lord, the suit for partition against me by impugning, and this is a specific statement I have made in my objection. My lord, can you consider if that be a preliminary issue, my lord, can you, in the injunction, I am suffering the order of injunction. My lord, can you turn to page 55? Yes, that has been completed, only some portion is remaining. That is the finishing, not the construction. The commission report has said. Yes. It can be granted. As status commander, what is the status is? I am on, my lords, repeatedly I have been directed finding out the, my lord, can you turn to page 55 once? Yes. I have already got it. And so for the commissioner report, my lord, I am drawing lordship on the commissioner report. From where your lordship will find that the construction is substantially completed. Not only that, page 74. No, okay. I Alamondas, my lord. I am on the Alamondas. Yes. Before that, my lord, I'll draw your lordship attention only on the deed itself. Yes, page 75. Page 75. Page 75. Yes, page 75. Page 75. The commissioner report, page 75. Regarding point number 1, my lord, got it? Page 75. Point number 1, my lord. This is the construction of the defendant number 1 and 2 of the appellant before your lordship. To discuss the point number that yes, the Paka structure is the suit property now details from the western side. There is one Paka's 3-story building which is 3-story from the front side and 4-story from the back side. Total building is full complete from the outside and also painted. The ground floor of the said building is used as commercial purpose. So after that, in the middle portion, next page, my lord, the middle portion, there is also a Paka 2-story building which is incomplete from outside, without plaster, and fully complete from inside. I'd like to state that some building materials are bricks, bamboos, wooden ply. This is mine. And the rest portion is point number 2 is the other person. This is Sina. Volume. This is 1. Substation allowed to be make construction and well, volume 1. Yes. আলামন্দাস ওই জাস্ট বলছেন and the schedule from the deed itself, it will appear that the demarcated portion has been transferred. And that is what is held by Lord Justice what there's a common owner. Here is the common owner transferred. And my Lord's judgment in my Lord is preemption proceedings also on that. With that. It cannot be. Undivided party. No, Malad, here the sole owner. Kutubuddin was the original owner. It is admitted in the plaintiff itself. He transferred by a demarcation. He from them there. Then how the partition suit is maintainable on basis of which, when it's specifically mentioned, and the commission report exclusively have shown that the portion how demarcated sorted by boundary wall. Hey, citation also 2008 volume 1. Yes, volume 11 2008 volume 8. देखिए two deeds are produced with the code below. The code below never consider those deeds. Here your lordship will find that as for the deeds which have been filed by the defendant in support of their objection, it appears that the predecessor of the defendants, number 1 and 2 and 3 to 6, purchased the plots by virtue of deed being number such and such. And those deeds are by way of demarcation and specifically delineated, and basis on which I asked my junior to bring the 2008 volume 8 volume page 1.
Kindly comes to Milord. Yes, Milord, I need not. Kindly see Milord. No. Kindly see Milord page 76. Kindly see page 76, Milord. Yes. Yes. So that was there, Milord, from the very beginning. Kindly see, Milord, regarding point number 3. Point number 3. Kindly see the last line of that page. Kindly see point number 3 and the answer given to that. Page 76, last line. Page 76, last line. No. He says no. Therefore, my learned friends that is true. So, Milord, kindly. No, kindly see, Milord. I am concerned with the incomplete from outside. But whether that is a new construction or old construction, whether neither my it may be an old one.
As a questioner, you will deny him from bringing any furniture in house. Can you deny him replacing the rotten the window pan, the new pan as a questioner?
No.
So another right as a questioner. He has an equal right.
No, that no.
Cannot infringe upon his right.
He has not filed any application to that effect.
Not required. Why he must be some permission?
No, what are the requirements?
Seeking permission to visit. He will seek permission to construct or repair. Or whatever, it's old or one. He needs to complete the plastering, he will do it. Here's the spirit and the system of the
Yes, exactly. Only that one. I will supply it. I will supply it. And it did not cause any prejudice. That is the finding for the purpose of granting an order of injunction. Nobody will be prejudiced.
Kindly comes to Milord, page 8 of the judgment. Page 8 of the judgment, Milord. Milord, after paragraph 13. Page 8, after paragraph 13. My lord has got it, is specifically alleged, Milord.
portion, that is what I am saying.
That is my exact obligation in the plaint.
There is already a construction.
That is my exact allegation in the plaint. That is my exact allegation in the plaint and the injunction application. But that is my allegation in the plaint.
No.
You have a structure. Don't you have a structure?
Yes, Lord.
So, as a co-chair, suppose, then can you correct it? As a co-chair, you are a dominant co-chair, it's a subservient co-chair. You will have a dominant. If a dominant citizen, and it is a subservient.
Well, kindly restrict it to the plastering works only. Because third party interest and Milord. You know, Milord,
the encircle
character, Milord,
and the deed
Milord,
itself
otherwise, Milord.
is a demarcated portion.
True.
Who will compensate him for this loss? One injunction, then we are putting, then you put
Yes.
25 lakhs of rupees as a deposit. He made it to law, if you lose, you will compensate. You put an officer.
No, in this matter, my lord has not accepted that view. Kindly comes to the subsequent paragraph. This point was also taken by Mr. Mukherjee. This point, my lord, that's why, my lord, I chose this one. I chose this one. My lord, this point is also involved here. My lord, kindly, my lord, do not restrict my third party interest, my lord, those are also there. My lord. Third party interest.
Nature,
Nature,
character, and position.
Nature, character,
Only nature, character,
alienation is
position.
also there. Alienation is also there. Alienation is also, that is also protected by my land. Yes.
Position, nature, and character, and alienation.
Yes.
None. Yes, it is.
And nature and character, my lord, nature and character only to the extent of repair and renovation.
Yeah, I'll mark that portion.
But that will not, I will be in difficulty. Again, I go on adding them parties, subsequent purchaser, go on adding them
List
parties.
matter transferring. That is the judgment was from our honorable court. Previous to that, don't know lot. It is from our court. As well. As well. I'll bring that judgment tomorrow. Get a photocopy of this. If your lordship wants, my lord, that is 26 decimal. I've gone through the records, my lord. Is it the correction matter, my lord? Yes. I've gone through the record, my lord. What is correct is what is submit is correct. 26 decimal. Admitted 52 decimal land out of his half portion. So it is 26. Grateful to your lordship.
My lord, your lordship has seen the interim order passed by a coordinate bench. Yes. লিস্টে দিয়ে দিন লিস্টটা ডাকলে 4টি মিটিং আছে
Other matters released. Other matters. The other matters. Other matters. I have the next one 24.
Last he told me just that he would be here. So Mr. Dotto was supposed to be here. He told me that he would be here at 3:30. Where is he? দেখ কেউ গেছে ফোন করে দিতে তখন No, regarding the matter, this matter, when it was taken up in the morning. No.
ইনস্ট্রাকশন নিতে সেটা এখনো আমাদের কিছু বলে
Copy দিয়েছিস?
না আমার সব
Copy was served upon him, and he was supposed to take instruction.
কথা বলেছে
No, he has not indicated because he met me in the morning after just going out from this court, Lord. Okay.
Stuck up the code number. Just I will talk to the department. Other things that for the interest of the state, the lordship wants to release. If your lordship wants to considering the interest of the public, your lordship can release the pass an order for release. But kindly do not record my concessions for release order. And they are telling the problems, so whatever the problem they are facing. And so far that issue is concerned, that answer is there in the rules. So far authorization is concerned, that authorization. Yes. But can you consider the rule 7? Mala Justice Prasad has rightly pointed out section 5, and so far the rule 7 is concerned in 2021. I just have handed over to your lordship. In case of casual vacancy, the officer does 4% of the presided what are the members of the officiate as a chairperson? That power has been given to the state government. No, 7 small d.
You're right.
ED.
Right.
But this is the Central Government rules. Question judge of the High Court, retired judge of the High Court.
Act is also of the central government.
This
You're
is
saying central government rule as if it becomes higher by saying it is central government. It will not go higher than the act.
But this is the parliamentary legislation placed before the parliament.
If it is these are the subordinate legislation.
But it was placed before the parliament.
I am against it.
if the subordinate legislation is in conflict with the parent act,
Parent Act,
because the source is derived from a parent act,
Parent Act.
then which will prevail?
But a Parent Act will prevail.
Then is it under 36? Is it under section 36?
No, it is exercise the power under section.
Rule-making power has to be.
Section 3 of the Administrative Reforms Act 1921. Just a, may I hand over a copy of this? Twenty-one Act. 21 Act.
33 of 21.
Section 3.
No. Section 3 of the Tribunal Reforms Act 2021.
Section 3 is not a rule-making power. What is the other?
The qualifications for notwithstanding anything contained in either judgment and degree or order parts in the further made by notification of official gazette, rules provide for qualification for appointment, salaries, allowances, resignations, removal, and other conditions subject to the person. Members of the tribunal, after taking consideration the experience, specialization, field, provided the person has not completed the age of 50 years, shall not be eligible for appointment as chairperson or member. Then, Manat, can you see the rule? That is at page 17. And rule 7D. Casual vacancy. And kindly see section 32 of the 22:1. Every rule made under this shall be laid as before the each of the house of the parliament. That means parliament has got the knowledge that 1985 Act is there, 2021 Act is there.
It was with central government, about 35, section 35. Central government is
21 Act আছে।
Where is that advocate general?
একটু দেখে নিয়ে 14 নম্বর কোর্ট আছে, একটু দেখে নিয়ে 14 নম্বর কোর্ট আছে।
And lastly, order. So that I can.
Yeah, but
That is my judgment.
Yes,
Sir,
your
yes, I have had it.
page 92. Lord.
In the morning, I have had it.
Yes.
No, no. On a sober constitution of a functioning of the tribunal.
No, on this.
But the identical situation, in identical situation, your lordship passed an order dated 13th March 23, page 92.
53 at order.
Yeah, okay.
56 is also an order. Passed by his lordship. Taken a cost imposed.
56 is also your lordship's order, page 56. In that matter, your lordship imposed 50,000 costs.
That is page 56.
Which one?
Page 56. Page 56.
এখানটা clarify করে দিয়েছে। 6. 61 এর executive approval বলছে
96.
6, Lord. 56.
From 56. 61 থেকে cancel করে 61 থেকে
And your lordship clarified the situation at page 61 and operating part is page 62.
In what he's taking at what provision of law he is relying upon?
greater public interest.
No, Lord, only dearth of doctors greater.
Some provision.
He has relied upon two decisions of the.
Lord, page 77. Your lordship sees, Lord, the reasoning.
Greater public interest and there is acute shortage of facilities.
Yes.
Faculty. Relying on certain.
Yes.
Reasoning.
In the greater interest of public service, as there is acute shortage of faculty.
Where is the provision that he can do it?
Release from the government is necessary. Release from the government is necessary.
No, I understand. Then from where you got that power that you can withhold? You are a government. You are a creature of a statute. You have to follow the statutory provision as well as the constitutional provision. From where you got it?
But in the interest of our country, what this?
Public interest. You can do anything.
No. What are, if one finds that any of my observations made therein is a contrary to the public interest, public interest will private interest will public interest will prevail over the private interest.
Without it.
There is no order.
That was a judgment which this was a judgment which was passed by me.
Absolutely.
Yes.
It's 56.
So this Samir Rana is a
No, that is by a coordinate bench, Lord. Present one. There is no leave granted to the state to pass further reasoned order. There is no leave. Only affidavit was directed to be exchanged.
And but the state government relied upon 2018, volume 17 SSC, page 578, paragraph 37.
He's employee of the principal secretary or he's an employee of the state government?
Employee of the state government.
So where is this order says that it is under direction as directed?
No, executive power by under Article 162.
Is this 164? It doesn't give the principal secretary. It must have the approval of the state government. He cannot sit and write an order like this.
Under state government, governor.
Every day memos are issued by the principal secretary. It starts with as directed.
But when the reason order is passed by the government, when the earlier order was considered.
Not an order of the government. This is an order by the principal secretary himself.
Yes.
And therefore there is no memo or nothing.
No,
he's sitting in his office and writing an order as if he is serving the principal secretary.
In a reason order, no memo can be issued. Because
is this